Well, good evening, everybody. Hi. Hey, Danny, you were first. Danny. Hey, Moonvale. Hey, P. Fox. I put the link for the case of interest site in the chat in case some of you guys want to pull up the documents and sort of like follow along instead of just following along on the screen. I know sometimes y'all like to pull up the documents. Hey, Ample Spark. Hi, Kylan. Hey, Tara. Hey, Red Riding Hood. Twisted Tea. MDP, Miller time. Hey. No, I did not, but I do have it pinned, like starred in my email, along with a couple of other things that I've got to get to this week. It's there, but I'm going to look at it because the way that things have been blurred lately is interesting, and I'll do a video of it if I see what you see and credit you for all of the things and ask you a few questions before we put it out there, if you put it out there. But it is interesting what you claim that you saw. Hey there, Susulala. Kissy times 3. Hey, Jitsu 222. Salty Grace. Yeah, I think the first one we're gonna go through, because normally my OCD has to be like, oh, we're gonna go through these in order that they are filed, which is probably gonna end up being the case, but I think we're gonna go over the Bushy eyebrow paper first. Because there are some interesting things in there, and I think that one we just need to knock that one out the park now. Because once you hear a certain sentence be read out loud, it's going to hit you. Exactly why we're going to go out of order and do that one first. Because it is absolutely insane. Hey, Teresa B. Hey, Danny Anderson. Yeah, we're going to do, well, I might stay on until about 10 o'clock tonight. I'm done with everything I need to do for now. Kids are fed. They're preoccupied, all the things. We might stay on until about 10, but we're going to be doing 2-hour blocks until we get all of these documents done. Because like I said, it's easier and we'll get more out if we do it live like this in blocks than it is for me to sit down, record, go back, edit, download, upload, all the things. This is just going to be a lot easier. And that way we can try to figure things out together. You guys can ask questions in real time. Hey, Meg P. Hey, Gina P. Hey, Shannon. Hey, Too Fast for Fleas. Hitman 23. Laura Woods. Falcon Quest. Green Eyes. Steve W. Batshit Crazy. Bella. Marine Hughes. Doc. Erica. Quality Emerald. Yeah, that one, that's the first one. We're going to have to read that one first, okay? Because look, once it gets to that one part, I was like, holy crap. I'm trying not to spoil it. Hey, Michelle. Yeah, they're insane. Ooh, it has photos? That'll be cool. Hey, Daniel. If you go to the channel and go to, let me show you. Because people ask this. I had it in my description box for like a long time, but oh, what's happening? Oh, hold on. I get a lot of like batshit crazy emails. Okay. So I make it to where you have to at least like click on a button or so before you can just get my email. I think it does it like this. Let me show you. So if you go to more on my channel and click right here for view email, it'll have you prove that you're a human, and then it'll give you the channel email. That's how I have it set up because people be crazy. So you can get it that way, and then you can email me. We'll do it like that. Let me get this back off the page. Hello, Sean D. I mean, when it comes to what she's claiming to have seen and how that is imprinted in her brain, girl didn't really see much of anything. Have you? There's been a few. We've been doing it for documents mostly. I've been trying to do lives every Thursday since the beginning of the year, and then the members only stuff the last Monday of the month. And so far, I've been keeping to schedule it. I'm so proud of myself. We have until April 16th. There's something on. Was there something on 4/9? You might be right. I'll check that out in a minute. And the freaking page has a new look. Okay, so for those of you that have, well, thank you, Green Eyes. So for those of you that have your notification bell like on to where you get everything that I post, you're getting my community tab posts as well. And let me see if I can pull it up so I can just go ahead and show you guys. Yeah, so about 3 hours ago, I was like sort of freaking out because the page all of a sudden, oh, this thing's acting crazy. Hold on. The page all of a sudden like went wackadoodle and give me like this crazy looking like update thing. Okay. And then I went back to it again and it went back to normal. And I was like, okay, well, maybe whatever update they were trying to do didn't take. But no, they've officially done whatever they were trying to do, and their new Outlook is like up and running so far. And hello to anybody that I haven't gotten to. We're gonna go ahead and get started. Hello, hello, hello. Hey AR. Hey Beth. Hey Gypsy Lola. Hey Jeannie the crime tourist. Hey, getting along everyone. Let's hope so. Now, again, we always encourage for people to be honest about their opinions on things, but make sure that your opinions are based on true facts. And just because you disagree doesn't mean that you can come out here and be in a poof face. So let's just keep it copacetic. Let's do it like that. Okay, let's pay attention. This is kind of cool because it has it in like a better chronological order. And they have, let me see if I can make this bigger so you can see it a little bit better. Like, it tells you whenever one of the documents is new, because see how there's like a gap of ones we've already like opened and seen, and then up and down right here. And then it has whenever everything was in Latah County for all of the years. And then whenever it switched over to Boise, and it's in order. It's kind of cool. And then like the front of it, oh no. What just happened? Oh my God. Well, let's see if it lets me open a page because I don't need no issues. Okay, so I guess it's just the home page for now that's freaking out. Okay, let me get off of this part. Okay. There's a lot of these. Now we expected 40 plus, but it looks like that actually did get sort of like cut in half because this morning I released a video for the most recent documents. We did the judge's order last night, but there was like 2 of them that I either completely missed or that popped up early this morning. They've popped up documents at like 9:30 in the morning one time, which was randomly odd. So I don't know. I don't know when they posted, but it was basically stating that all of the exhibits were going to be sealed, all of the exhibits. And that just like in the order where they said they were going to be doing redactions over the whole document being sealed, there was one of them that we did go over yesterday about 2 of the motions being completely sealed. And it looks like it's just because it is the like unredacted ones being sealed. And then they did these like public access ones. So we have about 20 plus filings from the 40 plus that we had because all of the exhibits are not going to be allowed to be seen. But there's a lot here. That's why I said we're going to have to do it in like blocks because there's a lot. But luckily, I've skimmed through. Well, I'm going to give you like just like a pre-opinion, I guess. So far, the longest one I've seen is 11 pages, and I believe it's the Bushy eyebrow one. If I can remember correctly, a lot of these are like 2 pages. They're not really that long. But I'm not sure. But we're going to go over the one about Dylan first because it's the most interesting. See, I see some of y'all already talking about it. There's some interesting stuff in here. Okay, and yeah, I like I said, I'm skipping ahead, and there's plenty. There's plenty, but we are going to start with motion number 7. We're going to start with number 7, and then we're going to go in and we're going to go from number 1 and go through all the way to number 14. There are some that do not have numbers. We'll probably end up going through those like at the end, like the last video will be all the ones that are not the actual motions of limine. So for 2.5 hours, we're going to go ahead and go through these at a time. Okay. Okay. Are you guys ready? Because this one's interesting. This is a motion of limine number 7 filed by the defense team, Bryan C. Kohberger's team, regarding the witness identification by bushy eyebrows. And the only person that we know of that said that so far is Dylan. Comes now Bryan C. Kohberger, by and through his attorneys of record, and pursuant to the Idaho rules of evidence, moves this honorable court for an order in limine excluding any evidence referencing bushy eyebrows. More specifically, the defense asserts that rules 403, 601, and 602 of the Idaho Rules of Evidence bar witness Dylan Mortensen hereinafter DM from using the words bushy eyebrows or identifying Mr. Kohberger in that manner. Now, we have to remember that in the hearings, what did Jennings just like blurt out of nowhere without anybody even asking? Literally, that Dylan Mortensen was shown a photo of Bryan Kohberger and did not recognize him. And I find that interesting because even if you didn't recognize a person's actual like face and you didn't actually recognize the person, something about that person's face shape should spark something in your brain if it's connected to something so serious. So the way that his eyebrow sort of like protrudes a little bit, the way that he has deep sockets, his eyebrows are not bushy. He just has a very prominent like face shape in his eye area, and his nose is bigger than normal. Like he has he has features that are not, I guess, ordinary, I guess is what I'm trying to say. That didn't spark anything to her. So remember that. Introduction. The issue of witness identification is a critical one in a trial that is the subject of much litigation. That is because the reliability of witness identification is the linchpin in determining the admissibility of identification information. And it cites State versus Hoisington from 1983, but they then again omitted the citation. Failure to challenge unreliable witness identification can result in finding that trial counsel's performance was deficient and provide a basis for overturning a conviction. And then they cite Werdeman versus State from 2017. In this case, the description provided by Dylan is unreliable and should be excluded, although she has never identified Mr. Kohberger. Testimony by Dylan from the witness stand describing bushy eyebrows while Mr. Kohberger sits as the accused at trial will be as damning as her pointing to him and saying, he is the man that did this. And based on the way that the human brain works, I just want everyone to reference back that has followed, okay, the Delphi case. I've skimmed through so many of these, well, not so many, but like 4 of these documents so far. And a lot of the things that they're talking about, I keep referencing back to what happened in the Delphi case. You'll see that like the similarities, circumstantial similarities, it's ridiculous. When considering whether identification by a witness is reliable, the Idaho Supreme Court has applied the Manson-Biggers balancing test, which looks at the opportunity of a witness to view the criminal at the time of the crime, the witness's degree of attention, the accuracy of the witness's prior description of the criminal, and the level of certainty demonstrated at the identification, and the length of time between the crime and the identification. And then it cites Werdeman versus State from 2017 again. And apparently in that case, they cited State versus Trevino from 1999. When Manson-Biggers balancing test is applied to the facts of this case, the reliability of the witness identification is non-existent. Dylan is the only person alive who is known to have seen the intruder. She only saw the intruder briefly. Her recollection or lack thereof is filled with uncertainty, fuzziness, the influence of alcohol, dreaming, and sleepiness. She did not see the intruder well enough to describe him in a composite artist. So I guess they didn't do a sketch. Because I asked that too. I asked if they did a sketch, even though apparently he was in a mask that covered like the bottom portion of his face, because they did it in Delphi. They gave out one. I think the guy had a beanie on in a handkerchief. Yeah, apparently Bethany never saw anything, or at least didn't see the intruder to where they could make like any sort of identification. We don't really know. The way that they put it, the way that it's worded later on in this document, no, not really at all. Her recollection, we weren't that far. Okay. After Mr. Kohberger was arrested, she did not recognize him from a photo, which again, Jennings blurted out of nowhere. Now here we go, guys. This is where we're going to get to where she says things. And I hope nobody put this part in here yet. I hope nobody spoiled this part yet. I see stuff about a firefighter, but don't say nothing about anything else. Just listen. Relevant facts. Bushy eyebrows. Number 1. Interviews on November 13th of 2022. Interviews. There was 2. On November 13th, 22, Dylan was inside the house when the murders occurred and saw a figure dressed in black, hereinafter intruder, when she peeked out of her bedroom door around 4 a.m. Shortly after seeing the intruder, she went downstairs to Bethany Funk's room. The 2 girls fell asleep. Yeah, I don't believe that at all. I just don't. I just don't. Roughly 8 hours later, a 911 call was made from Bethany's phone at 11:56 a.m. Bethany's phone. Why they had to keep it such a secret that it was Bethany's phone that the 911 call was made from? Why? Because haven't they kind of been alluding this whole time it was Dylan's phone? Oh, 4 months, Moonvale. That's great. Oh, and you gifted 5 memberships. Thank you so much for that. Thank you. That's very sweet. Yeah, they've sort of alluded the whole time that it was Dylan's phone. And it's not. It was Bethany's. So that's new. The 2 girls fell asleep. No, okay, we went past that. Now, apparently, the Bethany's phone situation is going to be in the motion of limine number 7 exhibit about Nunez's narrative about him being a first responder and I guess talking to Bethany after the 911 call was made. Now, again, remember all of the exhibits sealed up. More than 8 hours after seeing the intruder, Dylan was interviewed by law enforcement at the scene and at the police department. It was confusing to Dylan that the intruder looked at her, but did not come towards her or say anything. Remember that. Please remember that, because I'm going to get to it and you're going to be like, holy hell. Just remember, it was confusing to Dylan that the intruder looked at her, but did not come towards her or say anything. And again, this is added to the exhibit number 2 when it comes to the body cam transcript from Nunez. And is there a footnote? We're going to get to the footnotes in a second. I want to get to the point of this. Nope, I can't. Okay. The full transcript of the November 13th, 2022 interview by Officer Nunez was attached to a minute defendant's memorandum in support for a Franks hearing as Exhibit D8A at page 270. So this was in there. After you guys hear what I have to read to you, you're going to wonder why the judge didn't grant this. And then the second one was a full transcript of the November 13th, 2022 interview by Detective Mowry was attached to this exhibit. Okay. So then she says, when describing the intruder to Officer Nunez at the scene, she described the height, build, and clothing of the intruder. Her description did not mention eyebrows. So her first description didn't mention eyebrows or a vacuum type thingy-mabobber, okay, at all. Her description did not mention eyebrows. When she called Bethany before going downstairs to Bethany's room, so proof, which we already knew, there was contact and phone calls going out of Dylan's phone to everyone else in the home. Dylan said that she was kind of in and out of it. I was really tired. Later, when she was interviewed at the police department, Detective Mowry inquired about facial features and asked Dylan if she knew what color the intruder's eyes were. And this is Mowry's transcript, again, in an exhibit we can't see. She did not know the color of the intruder's eyes or eyebrows. Everything was kind of blurry. I don't fully remember it. During the Mowry interview, Dylan again mentioned that she was in and out of it because she was so tired. Now, this is where I want you to pay attention. Are y'all ready? I want you to be ready. Remember what was said about how Dylan felt it was confusing that the intruder looked at her but did not come towards her or say anything, okay? Keep that in your brains. Okay? Pictures on November 13th of 2022. Law enforcement took pictures inside of Dylan's room on November 13th and on November 19th of 2022. On the walls in her room were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, and perhaps subjectively bushy. She didn't frickin' see nobody. She looked up and looked at her frickin' walls. She's describing the intruder as an art project on her fricking wall, guys. She literally is describing her own freaking artwork as the intruder's freaking face. Yes, now y'all get it. Now y'all get it. She's describing her freaking artwork. Like, are we so serious? She's describing her artwork. As soon as I read this, I was like, no freaking what? And Hippler doesn't give a shit. This is what this is. Are we for real? And there's an exhibit, of course, that we can't freaking see. And then there's more. It says, according to Detective Lake, he found artwork of human figures with an emphasis upon the eyes and eyebrows were pinned to corkboards. So does that mean that she had pictures of humans sitting on a corkboard like freaking voodoo dolls? Is that what that's trying to tell us? Yeah, they're going to have to. Yeah, Lisa, they're going to have to. They're going to have to show the pictures of the bushy eyebrows all over Dylan's walls. She is describing, frick yeah. It's freaking unreliable. Oh no, Lisa, you don't have to rewind, honey. I'm going to reread it. I'm going to reread it. I'm going to clip this for tomorrow so it can just be a brand new revelation for everyone in a very, very short video, because what? What? She's describing the intruder as her freaking artwork. Yeah, creepy. Like, I understand maybe having like an art book and like you're doing sketches and stuff in there. Like, my teenager would like put makeup on and like kiss the heart-shaped thing that she drew on her wall to like make artwork. And she had pictures of eyes. Like, I think a lot of people that like learn how to draw or like to draw, they draw eyes. I used to draw eyes all the time. But whenever everything that she's drawing is literally fitting the description of the intruder to a T, are we for realio? Bro, you can't tell my kid anything different. Especially about Dylan. I'm about to read it again. Y'all ready? Are y'all ready? I'm just like, what the shit? This is not a laughing matter, but what? What? Okay, I'm going to read this part one more time. It was confusing to Dylan that the intruder looked at her, but did not come towards her or say anything. Law enforcement took pictures of Dylan's room on November 13th, 2022 and November 19th of 2022. On the walls in her room were many pictures of eyes with prominent eyebrows, many of which she had drawn. Some of the eyebrows are heavy, voluminous, puffy, or perhaps subjectively bushy. According to Detective Lake, he found artwork of human figures with an emphasis upon the eyes and eyebrows were pinned to corkboards. That's also creepy. Like, again, I guess because I'm Cajun and I've like been told that my family has been cursed for many moons by voodoo witches. I guess that's just like the first thing that I think of by hearing that there was human figures on a corkboard pinned with pins, is that she's doing some corkboard voodoo and drawing big ol' eyebrows and shit all over her room. Welcome, Green Eyes. Bro, show me the freaking photos. Get off the floor, Lisa. Hey, Elser. Bro, that's what I'm saying. And like, they're just saying alcohol here. Nah, I don't give a damn. Y'all done already said she thought that she was hallucinating, that her mind was playing tricks on her. No. And then we have what we went through with that crime analysis guy had been told before December 3rd about her tripping on hallucinogenics and stuff like that. And I'm like, bro, so she was on something. And she was thinking that the freaking eyeballs on her wall were coming at her and doing stuff. That's almost enough for me to believe that she was on some sort of like psychosis trip. That makes it even more plausible that she could be involved in this. I'm sorry. That could be offensive to whoever it wants to be offensive to. But whenever you're sitting here and this is where this is coming to where you're describing the intruder by your artwork on your walls, and there's an 8-hour delay in phone calls, and now you're saying that home dude had a freaking vacuum in your hand, the latent footprint in your threshold of your door, meaning your door had to be open in order for that to happen. None of your freaking story makes any sense. Isn't that wild? We'll calm down now. I could go on about all of the things in my freaking head that are coming out of this right here. And that's another thing. Why was Kaylee so important? Why was Kaylee so important? Why was Kaylee the one that had to go to this freaking party with her to where the way that it's making it sound, she drove all the way to Kaylee's parents' house to ask her in person to be her freaking date to this freaking dance for what? See, I'm too scared to try mushrooms. I won't do it. I won't do it. Not even whatever they're selling at the store in these little thingies or whatever. I'm not doing it. I like my mushroom coffee that really don't do nothing but give me some minerals, I guess. I don't really know. I mean, I like to saute them down with some butter. I like to put them in my crawfish boil and eat them, but that's about as far as mushrooms I'll go. How can you hear this stuff and not be like, what? So she is describing the intruder, but not, because the reason why it's not talking to you and not coming towards you is because you're opening your eyeballs and staring at your walls. That's what's happening. I mean, yeah, technically, because the story that I got from that situation was from the memorial. And what I was told by people that spoke to frickin' Christy was that they were both at the memorial whenever those damn letters were read. They were just in the back. And that whenever they wanted to go and talk to them, Bethany ran off and Dylan was like, oh yeah, I didn't hear anything. I was asleep. But Jack apparently had already heard her on the phone talking to somebody at the scene whenever he walked down there before he got taken off to go be interrogated by the police because he was the ex-boyfriend. He heard her on the phone. They better have, man, they better have drug tested them. There should be toxicology coming back for everyone in that house. Everyone in that house. I mean, I doubt that it would have just been one photo. They normally don't, as far as I understand, they never just show you like one photo. They show you several photos and ask if you recognize anybody so that it's not bias, is how I understand it's done. I could not know for sure though. I put that song on a short about the cat because she was on the desk with me and my dog Boomer was sneaking like a peek at her through the crease between the computer and the desk because he didn't like the fact that she was getting attention. Yeah, this is wild. Isn't this insane? All right, let's continue. Let's continue. Interview on November 17th of 2022. On November 17th, 4 days later, Dylan was interviewed by Detective Goop and indicated that she was really asleep, and probably very drunk when she woke up around 4 a.m. on November 13th. And this is, I guess, Blaker and Goop interviewed her together, maybe? And it's part of the exhibit. But it looks like it's just a transcript. The full transcript of the November 17th, 2022 interview by Goop was attached to, why isn't it video or like audio attachment? Why is it a freaking transcript you have to read? I mean, I understand like they should always make everything also have a transcript, but why isn't the like actual version attached as evidence? I wonder if they're going to play any of the like audios of the interviews at trial. Throughout the interview, Dylan expressed uncertainty about what she heard and saw and did not know if it was real or if it was a dream or if her mind was playing with her, which isn't going to happen if you've just been drinking and you're just a little bit tired. I mean, I'm almost 37. I've drank in my lifetime and been hella tired from not working and then got up and didn't sleep and kept on going because, you know, young. But I don't ever remember hallucinating from doing it. So there's just no way that she's going to blame it on the alcohol. We're just not going to do that. It just doesn't make sense. Dylan described the intruder and told Detective Goop that she recalled seeing his eyebrows, his bushy eyebrows, but she did not recall the color of the eyebrows. His eyebrows, well, I know obviously she's describing her artwork and not Bryan, but regardless, Bryan's eyebrows are not bushy. I have a video that I was going to put out this morning and then I didn't because I didn't get to finish going through all of it. So I'm going to drop it in the morning, but it's me reacting to the last crap that Nancy Disgrace put out. And she's constantly talking about his eyebrows. There's so many of these photos where you can barely tell that it's eyebrow because his socket is set so deep. And there's even like a bunch of like bald spots like in his eyebrow on this side, and they're not even dark. Like they almost actually look lighter than his hair on top of his head. Like they don't obviously understand descriptive things very well. She could just recall the bushy eyebrows, but not the shape or the color of them. In this interview, Detective Goop asked if Dylan had anxiety, which led to Dylan stating that she had a lot of lucid dreams of being kidnapped or chased. Girl. She indicated that she watched Criminal Minds and fell asleep to crime podcasts. So does 95% of the world, but we don't do that stuff. These lucid dreams began in high school. So is that like induced by something? There's medications for lucid dreams. So I don't know anything about this stuff. Like I've dealt with certain mental illnesses, like with people in my life that I've had to learn things on, but like lucid dreams and stuff like this, I don't know about this stuff. I don't know anything about that stuff. But is there medications for that? Right, like if I know what a lucid dream is, so for her to sit there and be like, I have dreams like that of being kidnapped and stuff like that, like that's wild. I mean, I don't really I don't know, she's getting some sort of like spiritual help. This last thing I heard. Lucid dreams means you are aware while you're sleeping. Yeah. Melatonin makes me feel sick. Like I rarely get hungover if I drink. Melatonin makes me feel like I'm hungover, and I'll take like a 2 milligram, and I just can't do it. It gives me a headache, makes me feel hungover. You see yourself in your dream and see yourself sleeping. See, that's crazy. So what if that's what, man? Exactly. Exactly, Bex. Meanwhile, this girl is partying and moved on. Yeah, she's like at college parties doing her thing. Like nothing happened. Like I've heard of people like training themselves to lucid dream. This is getting wild. Okay. Interview on December 1st of 2022. A month and a half later, Dylan was interviewed again and described the intruder. She did not see his eyes, but she saw one eyebrow or two, but it was just like this bushy eyebrow. So now she's saying a unibrow, this bushy eyebrow, not two. I could just see like an eyebrow, this bushy eyebrow. See, again, that's got to be like her artwork. That's got to be like her artwork. And remember, she also said that he was white, but she didn't know how he was white. Just that he was white, which is a wild statement. Okay, she did not remember the color or shape of the eyebrow. She just remembered it being bushy. She did not remember. Can I make this bigger? Yeah. She did not remember if she saw one eyebrow or two. Throughout the interview, Dylan indicated that she had always had really bad dreams, lucid dreams, and scary dreams. She did not know what parts of her recollections were dreams and what parts were real. Okay, but okay, well, look, if she's trying to say that everyone was basically hanging out until like 4 o'clock and then everyone went to their rooms around 4 o'clock, home chick didn't get woken up for 7 minutes later and was in such a freaking deep sleep that she doesn't remember whether she was sleeping or in dreaming or actually awake. There's not enough time. That's a good point. The white paper on the wall with the eyes and bushy eyebrows, that's where she gets the white, like her room color, her walls were white. Probably. Yeah, she's not credible whatsoever, but let's base the entire PCA on her statement. See, they could have used They could have used like the forensic download of the two roommates talking to each other, what they heard on the camera outside, what they saw where they see the like a car doing the 3-point turns and all that kind of stuff. They could have just literally used that for their timeline and probably like not put anything in there at all about Dylan and Bethany. And it probably would have, I mean, like obviously we would have needed to know about Dylan and Bethany, but for there to be like a PCA of a timeline, they could have put all this stuff in here without even describing anything that she said. Right? That's also like that's another good thing. Like, how do you freaking know what time it actually was? If you're going in and out and you're so out of it, or you're checking your phone, you don't remember whether the frick what you're seeing is real or not, but you can remember what freaking time it happened. And see, they could have gone based off that, based off of her calling Bethany's phone. Yeah, Home Dude's been sitting in jail for over 2 years because of some eyebrow art. Some freaking eyebrow art. This is so wild. Let's just continue because this is insane. I'm gonna have so many like thoughts all night about this insanity. Like what? Okay. What I want to know is if she's on medication. I don't know if her dreams are this bad. Is there not medications that can help you with that kind of thing? But I guess if she, I mean, in high school might be where she like started learning how to do the thing because it's something you can learn. I don't know. This is just so wild. This is so insane. Now this is the next part. This is the part that all of you guys were talking about right here. When she woke up that morning, she did not fully understand what was a dream or not. In this interview, she indicated that she thought that the person was a fireman. Well, firemen wear bright ass yellow normally coats. Really, because she's I mean, damn. How are you not supposed to freaking have a disgusting opinion of this person? And it's not just because like this is an insane story, but it's because she is apparently just like refusing to come back. I just don't get it. I don't know. Do firemen carry vacuums? See, that's another thing. For whose history? I mean, I want to know if she's on medications for these crazy things that she sees and feels in her head. Because for her to have night terrors like that, to where she's lucid dreaming that somebody's chasing her, doesn't that mean that she can see herself being like asleep in bed while also being chased around her own freaking house? A fireman. A fireman carrying a broom with one big bushy eyebrow. A clad in, see, that's another thing, bro. Firemen are not clad in black. So where'd the black outfit come from? See, the whole vacuum thing in the Nancy Grace review video, I'll probably let that go ahead and release tomorrow morning at some point. I make a comment that like she didn't say it the first time. And if she really is involved in some way and was helping clean up stuff, then she probably knows that there's like signs of something getting vacuumed up and it's just something that she's freaking saying. Yes. Yes, Tonka. She said freaking fireman. The second interview that apparently the vacuum, according to the judge's order, the judge's information, she didn't mention anything about a vacuum until the second and third interview. And then look, and then that whole thing right there, I'm here to help you. Who usually says something like that? A fireman. Like, I am... Yeah, her movements in text, it's going to be interesting. She's describing someone in full protective clothing. See, maybe, but she's got to describe what she means by fireman. Like, was he carrying an axe and running around with a helmet on his face? Did he have on a gas mask and a big, like, yellow freaking coat and ginormous ass rubber boots? Like, just insane. Just insane. Okay, let's continue. On December, this is the statement / affidavit in support of arrest warrant. On December 29th of 22, a statement submitted by law enforcement in support of the arrest warrant used descriptive information from Dylan's interviews. Dylan described the figure as 5'10" or taller, male, not very muscular, but athletically built with bushy eyebrows. And this is a statement of Brett Payne, which we've already seen. Interview on December 30th. So the next day, on December 30th of 22, after the arrest of Mr. Kohberger, Dylan was interviewed by Detective Lake and Detective Tullison. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online. So she went and freaking found him herself. Oh my gosh. Wow. When asked if Mr. Kohberger was the person that she saw in the house, she did not know if Mr. Kohberger was the intruder. She knew that the intruder had looked at her because of the bushy eyebrow. Eyebrow! Eye freaking brow. So she went and found his freaking mugshot the second that she found out that the person was arrested. That's insane. Yeah, now it's one eyebrow. Uno eyebrow. This is wild. This is absolutely wild. All that she remembered is some bushy eyebrow and all black, some sort of mask. One eyebrow, okay, so a fireman with one eyebrow dressed in all black with one leg. One print, one eyebrow. How the frick are you vacuuming with 1 foot, one eyebrow? You gotta, like, be the most talented person on the freaking planet. A peg-legged firefighter that wears an all-black outfit with one eyebrow. That doesn't talk. Or walk, apparently. Because he didn't come towards her. No, she didn't recognize Bryan. At all. She went to go look for the photo, and she was like, no, I don't recognize this guy. Wild. Okay. Grand jury testimony on May 15th of 2023. Subsequently, Dylan provided grand jury testimony and was questioned about what the intruder was wearing. She was again uncertain, and that testimony is attached but not quoted verbatim here, which is what they said in the order not to do was quote anything from the grand jury exhibits. But we know that even at the grand jury, she was uncertain. And what did we hear from Logsden slipping out some little nuggies during a freaking motion hearing? That at least 6 of the grand jury people needed more information. 6 is a big number. Okay, 6 is a big number for a grand jury. And somehow the true bill still went through, which I don't understand. I want to know from one of those freaking 6 people what tipped it. If you had so many freaking questions and they told you, well, we ain't got nothing else, bro. You're going to have to just come up with your opinion on this without me giving you a single fact extra because this is all we've got. How the hell did it go through? KLG 74. Remember. A remember. I don't think that's how you say it. A member again. Thanks for rejoining. Thanks for rejoining. That's the word. I don't know. I want to say 12 to 18. Does anybody know off the bat? Grand jury people, is it 12 to 18? Let me see. How many people on a grand jury? It says 12 or more. A grand jury must consist of 16. A grand jury must consist of 16 qualified jurors of the county in which the grand jury sits, but 12 or more members constitute a quorum. A grand jury can deliberate and take action if a quorum is present. This is the Idaho rule. So 16 altogether. But I mean, regardless, if it's 16 or 12, I mean, that's a giant ass number. It's a giant number. It's just wild to me. But that's what I'm saying, though. Like, 6 asked for more information because it wasn't good enough. But then they passed it. Okay. Reliability of, is this the right one? Yeah. Reliability of witness identification. Opportunity to view. Dylan peeked out of her bedroom. This is supposed to say bedroom door, not bed door. Dylan peeked out of her bedroom door 3 times after 4 a.m. on November 13th of 2022. 3 times. The 3rd time, she saw a figure dressed in black. Was it a figure dressed in black, or was it somebody walking or in the area of where she was looking and they were just in the dark? Which one? At the scene, she described the intruder as, so this is the first thing that she apparently said. He was a little bit taller than me, and I couldn't really see much of him, but I'm almost positive he was wearing a full black outfit. And he had this mask that was just over his forehead and over his mouth. And he didn't say anything to me, like, at all. So it was never clad in black. It was exactly what we've always thought, which is that it was law enforcement verbiage. I'm almost positive he was wearing a full black outfit. That's probably exactly what she said, what she actually did say. At the police department, her description of the intruder was similar. And then I opened the door again, and the guy is right there. And he's maybe my height, a few inches taller. Okay, but Bryan Kohberger is freaking tall. Like, I know that his license apparently, like, says only 6 foot or whatever. But the pictures of him being freaking arrested in the red outfit, there's some officers that people went in and got their stats for that are well over 6 feet, and Kohberger is like taller than these guys. So for her to be like a few inches taller, that's why a lot of people really question about like that step. Dylan's like 5'9". She's either 5'9" or 5'10", something like that. 5'9" or 5'10". See, and that's what I was about to say. There's a step. There was a step somewhere right before Dylan's door. So a lot of people were wondering, was he on that step? Yeah, the step. Was he? Well, he would have been like at the normal height for her to be able to compare his height if he was already up on that and walking towards her door, I believe. But if he was on the bottom portion and had not actually taken that step up yet, he would have looked shorter. Lisa gifted 5 memberships. Thank you, Lisa. Thank you, Lisa. Yeah, the step is a big issue. People want to know, like, was it before or after the step? Because it does make a difference. A step is like, what, like 4 inches? Sometimes steeper? Sometimes steeper. Okay, so here we found out about the lights. The twinkle lights in the living room were definitely on. It says there were no lights on the stairs. Dylan was uncertain whether either the kitchen light or the bathroom light was on. The kitchen light might have been on, but the twinkle lights in the living room may have been on. We know that they were on because they left everything the way that it was, the twinkly lights. Now, I don't know about the bathroom light or the kitchen light or any of those other things. I have no idea. Thank you for the $2 super sticker, Red Riding Hood. Thank you. It's very sweet. Thank you. So, yeah, that's wild. Like, this whole thing about her is absolutely wild. Degree of attention. Mortensen acknowledged that her brain might have been fuzzy due to alcohol and sleepiness when she saw the intruder. She stated that she had been drinking alcohol just hours prior to peeking out of her bedroom door sometime around 4 a.m. and seeing an intruder. Okay, but if you drank hours before 4 a.m., come on. Like, I wasn't born yesterday. She was intoxicated when she arrived home around 1:15, 1:30-ish. And there's an exhibit for that we can't see. She was probably very drunk and tired when she saw the intruder at 4 a.m. But she made it sound as if nobody went to bed until 4. Or at least that's what they've said. That's what the PCA has claimed. And it's been all lies. Accuracy of description. When asked if she could see the intruder's face, she testified that I wouldn't say I fully remember their face, but I remember seeing his eyebrows. So at some point I probably did see his face and I don't remember. Grand jury testimony. So so they couldn't quote prior, but they could quote the grand jury testimony for this one and no one said anything or redacted it. They made us wait for nothing. They didn't even redact it. During other interviews, she said he was wearing a mask. So in the interview, she mentioned a mask, but in the grand jury stuff, she was like, I don't know, maybe. I don't know. I don't know. Wow. I don't know. Oh, well, thank you. 7 months. Thank you, Jules, for always making a great place. Zelda too. Zelda's asleep. Her cat bed has like a cave bottom. And so I keep finding her in like my drawers. If I leave my clothes drawers open, I find her in there sleeping. So this was actually pretty perfect because she gets in the bottom piece where it's completely dark and then she just passes out, falls asleep, which is great because she's normally batting stuff around and driving me crazy. Thank you for the $10 super sticker. Thank you. I very much appreciate that. It's been insane. Hey, conspiracy girl, did you hear all of this? Did you hear all of this? This is wild. Yeah, give it up to Hitler for making it to where we don't have to keep everything so freaking quiet. That's what I want to know. I want to know the information about the damn DoorDash because there's no reason for it to be secretive. Why do we not know information about the freaking DoorDash? There's no reason for it. Okay. Levels of certainty. During each interview, Dylan was uncertain. On December 30th, 2022, after the arrest of Mr. Kohberger, Dylan was interviewed by Detective Lake and Detective Tolleson. When she learned that an arrest had been made, she found a mugshot of Mr. Kohberger online, so it's just repeating it again. When asked if Mr. Kohberger was the person that she saw in the house, she did not know if Mr. Kohberger was the intruder. She knew that the man had looked at her because of the bushy eyebrow, and again, it's just a singular eyebrow. All that she remembered is some bushy eyebrow and all black and some sort of mask. Several weeks after the murders, Dylan thought that the person she saw was a fireman. So weeks later, she comes back to was a fireman. See, to me, that's not a balaclava or however the frick you say that word. To me, if you're thinking that you're seeing a fireman, you're seeing somebody in a gas mask situation. That's how I feel like that would have been. But she still keeps going to this like one eyebrow thing. That's absolutely crazy to me. In her mind, Dylan thought that the intruder went out of the back sliding door, but she doesn't know if he actually went out of the back door. Yeah, because nothing in the PCA alluded to that either. Yes, girl, a fireman. Did you hear the earlier part? She is describing the intruder based off of her bushy-eyed artwork that is all over her bedroom walls, apparently. Okay. A fireman with one leg in a mask and one bushy eyebrow. One bushy eyebrow. This is insane. This is freaking insane. The sliding back door was not visible from the doorway of Dylan's bedroom. And we've always known that. We know there was no way that she could actually see if the person she was seeing actually went out the door or not. That was all speculation based on that stupid ass latent shoe print that now we're finding out is in the threshold of the door. You cannot get a shoe print or a print or anything to be inside the threshold of the door without the door being open. That doesn't work. So they've already proven that latent shoe print was literally all for nothing. Literally all for nothing. Okay, number 5. Time between event and identification. At approximately 4 a.m. on November 13th of 2022, Dylan saw the intruder. Roughly 8 hours later, the 911 call was made. More than 8 hours after seeing the intruder, Dylan provided a very limited and uncertain description of the intruder to two different officers. On November 17th of 2022, 4 days later, Dylan did not think that she could sufficiently describe the intruder for a composite artist. So again, it looks like they're just kind of like repeating the same thing over again. That's fine, whatever. On December 30th of 2022, after Mr. Kohberger's arrest, Dylan could not recognize Mr. Kohberger from a photo. Further, by the time that Dylan testifies at trial later this year, more than 3.5 years have passed since the murders occurred on November 13th of 2022. August, September, October, November. Whenever trial starts in August, we'll be 3 months shy of 3 years. Isn't that insane? Argument. Case law and Idaho Criminal Rules 601 and 602 exclude evidence of bushy eyebrows. With certain exceptions, every person is competent to be a witness. IRE 601, incompetency determined by the court occurs when persons whom the court finds are incapable of receiving just impressions of the facts about which they are examined or of relating them accurately. IRE 601A, Idaho law tends to favor the finding of competency. Well, you'd think that they would like sane people with brains that work to be, on the stand and making points, but, life shows otherwise. Under IRE 602, a witness must have sufficient personal knowledge of the matter to which he or she is testifying. Yeah, and Dylan doesn't know if what she saw was accurate. Her personal knowledge of the matter is not knowledge. It's uncertainties all the way around and impressions of her wall art. Again, I'm not going to let that go. I think the thumbnail, I'm going to have to put a whole bunch of like bushy-eyed wall art like all over the thumbnail because I don't see any other way that this is just ridiculous. Testimony satisfies IRE 602 if the jury or other trier of fact could reasonably find that the witness perceived the event. Evidence to prove personal knowledge may consist of the witness's own testimony. When considering whether identification by a witness is reliable, the Idaho Supreme Court has applied the Manson-Biggers balancing test, which looks at, we already went through these on the first page. 1, the opportunity of the witness to view the criminal at the time of the crime. 2, the witness's degree of attention. 3, the accuracy of the witness's prior description of the criminal. 4, the level of certainty demonstrated at the identification. And 5, the length of time between the crime and identification. And they cite those same two cases again. When the Manson-Biggers balancing test is applied to the facts of this case, there is no reliable witness identification. As explained in detail above, Dylan's opportunity to view was seconds at most. Her attention was influenced by alcohol and sleepiness, and the only identifying attributes are height in relation to her own, a skinny athletic build, and a bushy eyebrow. Just the one. I love it. Just the one. Thank you for the $3 super sticker, Kimberly. I very much appreciate it. Just the one. Just the one. Just the one eyebrow. So insane. Just the one eyebrow. He was wearing a mask. He has repeatedly, each time interviewed, she has repeatedly, each time interviewed, expressed uncertainty about what she saw. These general descriptors could fit millions of individuals. Her uncertainty is repeated in each interview, and at least 8 hours passed before she interviewed the first time. 6 weeks passed before she was interviewed by law enforcement the final time, and 6 months passed when she testified before the grand jury. Balancing the Manson-Biggers factors, there is no reliability of the physical characteristics that Dylan has reported. Mr. Kohberger does not have bushy eyebrows, but the artwork on Dylan's wall and that which she should draw eyes with eyebrows could be described as bushy, full, or prominent. There is great risk that at trial in front of a jury, her testimony will be viewed as a clear identification of Mr. Kohberger. This would be a false identification and would prejudice the proceedings in a way that must be avoided. I'm so glad that they are right where I am, like in the direct argument. Chick looked at her own freaking walls, blitzed out of her brain, and has no freaking clue what she's talking about. There's a reason why the person did not come towards her. So now it really makes me even wonder if what she's claiming to have seen really had anything to do with her opening her door or not. Because her bushy eyebrows on her walls are inside of her bedroom. So maybe it was just her like laying down after hearing everything. Maybe she did get up and open the door at some point. Maybe not as many times as she's claiming to have opened the door. But for her, if this is how her story is going, she definitely didn't see anybody walking around in nowhere. At least not where she could say anybody had an eyebrow of any kind. Literally at all. Rule 403 excludes evidence of bushy eyebrows as irrelevant and unfairly prejudicial. To be admissible, evidence must be relevant. IER 402, evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. IRE 401. And then they state to look at State versus Smith from 2022, State versus Sheldon from 2008. Whether a fact is of consequence or material is determined by its relationship to the legal theories presented by the parties. In this case, evidence of bushy eyebrows is not relevant to the crimes charged and would not tend to make any material or disputed fact of the crimes charged in this case more probable or less probable than it would be without the evidence. Could you imagine being the first responders and walking in to that crime scene to look around and you pop yourself into Dylan's room and see nothing but a bunch of big bushy eyebrowed eyeballs staring at you? Like, I just thought about that too. Like, did none of the people that worked for the state that went in and procured evidence and took photos, did none of them be like, she said what? But that's all over her walls. Are we sure? Like, none of them questioned that. Right? Like, what were they thinking? Knowing that they went in there and saw all these big old bushy eyebrows everywhere in her room, and then that's the description. None of them thought, Brett Payne, Mallory, where's fake Mallory at? Y'all better get it together. This is wild. Bro, something was. Yeah. Because she's falling asleep claiming that she's lucid dreaming. Well, if you're falling asleep in your bedroom that's surrounded by a bunch of crazy bushy eyebrows, that's what you're going to freaking lucid dream about. Insane. Insane. Just insane. The purpose of admitting such testimony is for identification purposes. Given the argument above, such testimony is inadmissible. There is no relevant reason to allow this testimony. Under IRE 403, this court may exclude evidence related to bushy eyebrows if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. This rule requires the court to balance the probative value of the evidence against the danger that the evidence may be unfairly prejudicial. Hold on. Okay. Okay. Even assuming this court concludes that the descriptive words bushy eyebrows are somehow relevant, whatever minimal probative value they may have is substantially outweighed by the danger of unfair prejudice and confusion of the issues. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. Dylan could not recall enough details about the intruder to provide a description to a composite artist. Allowing her to use descriptive words, bushy eyebrows, confuses the issue. If evidence of bushy eyebrows is presented to the jury might well believe that Mr. Kohberger is guilty simply because of bushy eyebrows. As a consequence, there is a danger that the jury would reach a decision on an improper basis due to evidence that is unfairly prejudicial. Conclusion. For the reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion in limine to exclude Dylan from using the words bushy eyebrows to identify the intruder that she saw, and to exclude Dylan from identifying Mr. Kohberger based on bushy eyebrows. Well, she can't take it back now. There's that. She can't take it back now. She can't take it back now. She went on her own accord and went and found Kohberger's mugshot. Instantly didn't recognize him. She can't take that back now because she somehow manifested a firefighter and somebody with a unibrow. So she can't. None of this, literally none of this. How? How are we here? Like, I don't understand. How are we here? This is wild. This is the dumbest thing I think I've ever seen in my entire life. This is wildly wild. Wildly wild. Homeschick is literally staring at her own artwork and describing the intruder based off of her own artwork. So let's recap. One-legged firefighter that wears all black in a mask with a unibrow eyebrow carrying a vacuum. That's what it is. There's not one. There's no sketch. I mean, there's the sketches that are on her eyebrow, her eyebrow drawings. But when it comes to the composite sketch, she couldn't come up with enough details to even do it. I mean, I guess there's a possibility that there's like a draft somewhere. But do they keep those? Do they keep the drafts? If they're not able to complete a photo, do they keep the drafts? Yeah, this is so crazy. Just wild. This is insane. This is so wild. I'm just shooketh. Okay. That's probably going to be the best one. I mean, I'm just assuming because it was insane. It does. Sounds like she was tripping. And she can't just say, oh, I was only drinking and I was tired. No, Miss Ma'am. No, you're sitting here talking about lucid dreams and stuff. There ain't no way that if they better have tested her. They better have rug tested that child. They better. This is so dumb. Her own artwork, bro. Her own artwork. I'm shook. Okay. So the way that they have these now is in some sort of like order opposite of how it used to be. So on the old page, everything would be at the top, oldest, and then the newest stuff, you'd have to scroll down. This is the opposite. The oldest stuff's at the bottom, and then all the newer stuff is as it goes up. Now, we've already gone through these in the last like 2 videos that we've done. So let's see. Let's just go ahead and go through these because honestly, these aren't really that big of a deal. They're not very big. And I'll have like the list of all the documents that we go through. Like I said, I'll probably be on until like 10. I'll probably stay on until like 10 to see how much of these we can actually get through because like I said, some of these are kind of small. So this is the motion in limine number 1. The rest of these we're going to go through in chronological order, but we had to touch that one first. We had to go to that one first. Okay, this is the first one. This is the motion in limine regarding inflammatory evidence. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves the court for an order preventing the prosecution from introducing irrelevant and unfairly prejudicial photographs, testimony, and other exhibits in violation of his right to a fair trial protected through the 5th, 6th, and 14th Amendments of the United States Constitution and Section 1, Article 13 of the Idaho Constitution. Such rights are protected through application of Idaho criminal rules and Idaho rules of evidence. Mr. Kohberger respectfully request this court order the state to not try the case through eliciting testimony and other evidence that is exceptionally inflammatory. Presenting the case in an emotional and inflammatory way is unfairly prejudicial. Any probative value is less than the danger. Additionally, the prosecution should not present the same information in a variety of ways, which is misleading or cumulative and a waste of time. So this is what I think. This is one of the ones where when I was skimming through it, it made me think of Delphi. Because again, what do we hear? What do we hear about from the lady from the grand jury that came out? That there was nothing that said that Richard Allen was guilty. The only reason why they even said he was guilty was because his voice sort of sounded like Bridge Guy. Like, never mind the fact that whenever Bridge Guy is talking, the voice is up close to the camera to where it's a louder voice, and the man that's apparently saying these words that they're saying is Bridge Guy is a little bitty ant on the screen way in the back, and he doesn't know how to throw his voice, so it's impossible. It's impossible. And they went off of uneducated people doing some sort of voice analysis that are literally just laymen. That's how Richard Allen was found guilty. And I think a lot of that had to do with the fact that the crime scene photos were shown. Now, while I agree that all of those things should be shown in court, I almost feel like unless there's something they can prove when it comes to the wounds themselves that can actually point towards guilt, then maybe those kinds of things shouldn't be shown until after somebody is found guilty and it comes to determining their punishment based on the severity, if that makes any sense. Because we heard from Andrea Burkhart and all the rest of them that were actually in the courtroom for all the Delphi stuff. And they said that the jury had a very emotional response when it came to the crime scene photos of the girls being shown. And that it definitely changed like the tone. And some people that were more like paying attention to details and facts, once they had that like emotional image in their head, like the whole courtroom, just gasped. Like, it was, the way that it was described was that you could like feel it in your bones when those photos got uncovered for the first time. And I can imagine that this scene was horrible. And the defense isn't wrong here. Whenever someone, guilty or innocent, but in this case, innocent, in my opinion, in the defense's opinion, innocent, when that person is on trial for something and you're showing all of these horrible photos, the human that's on the jury, they don't have a freaking choice. Their brain is going to associate what they just saw with the man being discussed, with the person being discussed, because it's their trial. So while I don't agree with things being held back, I agree with it being at a different time, if it's possible. Unless there's something that can prove the guilt portion of it, it should be held for the punishment portions, for the rightfully convicted. Does that make sense? Okay, so y'all do understand. Okay, I didn't know if I was like making it make sense. Because I don't want to be like, well, yeah, they shouldn't show any of those photos. No, all that stuff that's the whole reason for all of this case. Is Kaylee and Maddie and Xana and Ethan. That's the whole reason for all of this. Exactly. As soon as you saw the horror, you want someone held accountable. Exactly. So if you're supposed to be completely unbiased in order to prove or vote on someone's innocence or guilt, I understand the reasoning for this. It should definitely be held for the punishment phases. There's going to be a lot of people mad about this. There's a lot of people are going to be mad about this. But I agree with this. IRE 403 states, although relevant, evidence may be excluded if its probative value is substantially outweighed by the danger of unfair prejudice, confusion of the issues, or misleading the jury, or by considerations of undue delay, waste of time, or needless presentation of cumulative evidence. The case contains over 68 terabytes of data. And that's not from Kohberger, that's all together. They don't have that much data from Kohberger. That's all together for the entirety of the entire thing. Okay, the entire thing. This data contains thousands of photographs. Many depict roughly the same content, the crime scene. There are photographs that depict the deceased as well as the same location without the deceased, meaning scans and photos and stuff that were taken after the bodies were removed and crime scene was done. Multiple officers took photographs of the same areas, as they should, Additionally, there are many hours of body-worn camera footage. Oh my gosh. I want to see it so bad. Body-worn footage depicts the officers moving throughout the house. Oh my gosh. I can't even imagine like their reactions because they did not know what they were pulling up to. So to think that you're coming over there to a collegey area because some possible, drunk kid passed out and then this is what you roll up on. I can't even, they probably needed counseling after all this. Let's just be for real. Like, let's just be nice for a minute. They probably needed counseling after this. There are hundreds of photographs of autopsy proceedings. In addition to this evidence, over 100 officers and investigators have been involved in the case, and hundreds of people have been interviewed. Mr. Kohberger seeks to protect the integrity of his trial and request an order preventing inflammatory evidence, including testimonial evidence, be excluded. And then it states State versus Phillips from 2007 and State versus Babb from 1994, State versus Ellington from 2011, and says appeals to emotion, passion, or prejudice of the jury through use of inflammatory tactics are impermissible, which is exactly what happened in Delphi. That's exactly what the frick happened in Delphi. People were paying attention, seemed to be really paying attention to the facts that there were no freaking facts until the photos and until the horrible truth. Until the horrible truth. Mr. Kohberger acknowledges the Idaho Supreme Court has held that a photograph cannot be excluded merely on the basis of being gruesome. However, Mr. Kohberger is not making that motion. Rather, he is requesting the state be prevented from introducing inflammatory evidence. Multiple studies have found that mock jurors are more likely to convict when exposed to graphic photos. Kevin S. Douglas, I guess he wrote all this book about the impact of graphic photographic evidence on mock juries. And there's another one that was written called Gruesome Evidence and Emotion, Anger, Blame, and Jury Decision Making. Other studies have shown that judicial instructions to ignore such evidence are ineffective, while some are actually found such instructions cause jurors to place more emphasis on that evidence. Exactly. You cannot unring the bell. You cannot say something and then have somebody object to it and then it be struck from the record. Okay, but it's not struck from their freaking brain. So you can't. It doesn't work that way. It does not work that way. Humans are not built like that. And this is just literally a whole bunch of like stuff that was written about it. Mr. Kohberger's right to a fair trial, free from irrelevant, cumulative, and unfairly prejudicial evidence, is guaranteed by the Constitution of the State of Idaho and the United States of America, would be violated to allow exhibits depicting gruesome detail or the emotional reactions of the police officers at the scene or during their testimony during trial. No, I see. I'm gonna like draw a line right there. I'm going to draw a line right there because I'm not going to be okay with them trying to state that the first responding officers are not going to be allowed to speak at trial. That's taking it too far. I'm sorry. That's not going to work for me. I understand the gruesome, photos of the crime scene and all that other stuff. But first responders and the walkthrough of the scene and those kinds of things, I don't agree with them trying to say that stuff can't be on the stand. Like, how are we supposed to get like the full picture of everything? There's got to be like a middle. There's got to be a middle. I mean, yeah, maybe they can't just like go into like emotions. But then again, they're going to want to show the footage. There's a lot of it. Yeah, the first responders have got to speak. Thank you for the 1999 super sticker, Holly Berry. Thank you. Yeah, no, the first responders have got to. And that's another thing, like the bathroom situation, because there was rumors about the bathroom, and then that went away whenever the PCA came out, and Ethan and Xana were both found in Xana's room. Then the stuff about the bathroom went away. even though in the PCA, he's like pointing out where the bathroom is. Well, then we find out, a few weeks ago, that it's because Dylan is claiming that she heard crying coming from a bathroom. Well, now we know why the freaking bathroom was so important. I've wondered from the beginning about the drains and different things like that because of the 8-hour delay and how it really feels like somebody was cleaning some stuff up. So, of course, we're going to be questioning all those things. But to sit there and be like, oh, the first responding officers are going to give their trial and it's going to be too emotional for the jury. No, that you're going a little bit too far. You're going a little bit too far with that one. Going too far with that one. And that was the end of that. I don't think there's no exhibits or anything. Okay. But yeah, I agree with like the photos and stuff like that because that's a visual thing. It's not the same as somebody like getting up on the stand and speaking. But when it comes to a conviction, that kind of stuff definitely should be shown because it shows depravity of the psycho person who was responsible for stuff. So they shouldn't be doing that beforehand. Okay. Now we have the motion for vague and undisclosed expert testimony. Now, I'm pretty positive this has to do with the fact that there was apparently a bunch of experts from the state listed. I think they said there was 25 of them, and only 5 of those 25 had any sort of analysis, opinion, or report or anything like that attached to their stuff. Like all of the rest of them apparently had nothing. It was just like their names. And there was like some sort of generic templated excerpt that they kept apparently like putting on all of them, if I can remember correctly. And that's probably what this one is about. Now, this one's 13 pages. But I guess it talks about multiple of the expert witnesses. Okay, so this one should be pretty interesting. Comes now Bryan C. Kohberger, by and through his attorneys of record, and hereby moves the court for an order excluding vague and undisclosed expert testimony. Allowing vague and undisclosed expert testimony violates Bryan's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. This motion is based on the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 13 of the Idaho Constitution, Idaho Criminal Rule 16, and Idaho Rules of Evidence 102, 04, 701, 02, and 03. And also remember that the state made a comment about how something about it. This isn't like a poker game. All your cards have to be out on the table. There can't be like anything up your sleeve or anything like that. There's no trial by surprise or all those things. So I don't know why the state is thinking they can just turn in a bunch of like blank information and then call this witness and this witness say a whole bunch of crazy stuff that's not in a report, in an analysis, in an opinion, on nothing. They can't do that. They have to say and show what they're going to be discussing because I think the judge in the end has to decide whether it's relevant. Pretty positive. The Due Process Clause requires that criminal prosecutions comport with prevailing notions of fundamental fairness, and it cites California versus Trombetta from 1984. The requested exclusions are made to secure fairness in administration to the end the truth may be ascertained and proceedings justly determined. These matters are ripe for consideration by the court pursuant to IRE 104 based on the existence of issues that involve preliminary questions of admissibility and because the determination of these issues now fundamentally impacts the defense's ability to prepare a comprehensive defense and focus on evidence and experts that will actually be at issue in the limited time frame prior to trial. Mr. Kohberger hereby incorporates all arguments and authorities contained in his accompanying motion to preclude the DP and adopt other necessary procedures due to the state's numerous disclosure violations. And again, this is something else that stupid disgrace kept harping down on when it comes to the autistic disorder stuff that got filed. This is all things that have to be filed for the death penalty. This is nothing that's being filed in way of innocence or guilt. That's where she is misleading her audience into thinking that they're using this autism disorder as a get out of jail free card for what they're claiming that he is now saying that he did. Because according to Nancy Disgrace and her inability to use her brain, the only way this can be being posted and filed is if he's admitted to the crimes. No, because this is for the mitigation stuff. This is for the death penalty stuff. It has nothing to do with the guilt phase of anything. And I don't know, as an attorney, how she's sitting here and acting like she doesn't know that, except for the fact that she does know that, and she's out here purposely lying because she wants everyone to think, oh, he pled guilty, so that's why they're using the autism thing to help him get out of it. And that's not the case. Her entire video was so disgusting. So disgusting. Just wait. I'm going to drop it in the morning. I went off. I laughed. I got angry. It's everywhere. It's everywhere. Okay, let's get back to this. Mr. Kohberger requests exclusion and or limitation of the following expert testimony. So this needs to be either limited to what this person can say, or it needs to be excluded completely. I guess I'm not going to be able to actually put this how I want to because it's just not going to cooperate. Okay. Jeannie Ayers, or maybe it's Ayers, forensic scientist. Testimony must be limited to only her work depicted in the Idaho State Police Forensic Laboratory Report number 25 and her checklist of testing in Mr. Kohberger's apartment and office. She has not authored any laboratory reports expressing opinion. Any other testimony is outside of Idaho Criminal Rule 16, Idaho Rules of Evidence, and the court's scheduling order, and violates Mr. Kohberger's federal and state constitutional rights of a fair trial, confrontation, and due process. So, let's see. She can only talk about her checklist of stuff that she tested from his apartment and office, which we've known that there's no connection to anything in any of those things, but the Frank's Motion exhibit list titles that got released proves that in the titles, like very specifically that the things that were tested, there's no connection. But when it comes to, I guess, anything else, she hasn't posted or submitted any opinion. So she's only allowed to talk about those very small things. They're not allowed to ask her about anything else, is what the defense wants from this situation. Now it looks like they're trying to limit stuff from the feds. They want something done with Agent Balance. Okay. FBI Special Agent Nicholas Balance. Testimony must be prohibited as no report containing findings or opinions has been produced. What? What? Balance hasn't written a single report? He was literally located in the Moscow Police Department headquarters office on the second floor, sharing a freaking office with Detective Mowry. He has been lead. I don't give a damn what anybody tries to say. He has been lead. He has been the one interpreting all of the information when it comes to the cast report, telling Payne what to write. Exactly. It cannot be freaking hearsay. He cannot just come out there and be like, oh, this is what I remember from 3.5 years ago. The only thing that we've seen is some sort of like document. I can't even remember exactly when it was, but I know that it was just signed. Like, I think it wasn't even signed by him until 2024. Exactly. He literally told Moscow PD what to write. He was the one that was getting the information back. Like, they would file the search warrants and their shit would go to Balance. And then he would tell them what it says. And I'm like, you haven't written a freaking report? What? So, I'm shocked, but I'm not at the same time. That's how I feel, Holly Berry, that Brett Payne is the fall guy. I really do feel like he's the freaking fall guy. Because they don't know what the hell they're doing. And you know what else I found out that I didn't freaking know? I think, did Heather post this? I think Miss Potts posted it and then Heather reposted it, something like that. One of them is in here, I think. Oh, thank you for 10 memberships. Thank you, Lisa. Thank you, Lisa. Congrats to the winners. Congratulations. Did y'all know that there was a lead before Payne? that apparently this guy was the lead for like 24 hours and then all of a sudden Payne took over as lead? I didn't know that. It was apparently written down in like some WSU article or some shit like that. Like, they had his name and everything. So I'm going to have to look into that one because that's freaking interesting. Why did they take somebody off the lead and give it to Payne with no experience? And the guy he was getting all of his information from, that Payne literally got on the stand and was like, I got all my information from this guy. Like, let's be for real. That was the consensus from the beginning. And now we find out that to this day, as of 2/24, whenever all this stuff was filed, Home Dude has still not written a single opinion, report, nothing. Okay. Let's continue with the disappointment. The only disclosures are 2 PowerPoint presentations. One is noted as a draft. That would be the cast stuff, because the cast apparently is a PowerPoint, which we found out recently. Well, I found out recently. The PowerPoint depicts information derived from cell phone data, call detail records, drive test data, and interpretation of the same. It is abundantly clear that in creating this PowerPoint, Special Agent Balanced used an unknown methodology to analyze and visualize certain data contained within the defendant's call detail records while omitting and or ignoring other relevant data. So they don't have any notes or any information about what he apparently used, I guess, to put all this information together. It is impossible to determine why certain data was included in the PowerPoint while other data was omitted, ignored, as Special Agent Balance has produced no report documenting his actual analysis. Well, I hope that the defense has the list of things that should have been implemented into that analysis that aren't, because you'd think that they would have that to be able to say, hey, you should have had this in there and you didn't. I'd like to see it. I would love to see it, especially after this next sentence. The omitted/ignored data referenced above is exculpatory evidence in Mr. Kohberger's defense. So the reports that would technically have information and it's exculpatory evidence is magically what's missing, because the Fed that has that information is refusing to file a report. I don't even know how to feel anymore. I'm numb. I'm numb, but I'm not at the same time, because you just cannot help but be shocked by the incompetence. The incompetence is insane. I'm just wow. Let's repeat that sentence. The omitted/ignored data referenced above is exculpatory evidence in Mr. Kohberger's defense. The call detail records in full provide partial alibi corroboration. As such, the complete lack of disclosure as to any opinion and or report addressing this issue from Agent Balance makes it impossible to anticipate what he may testify to as an expert on this matter. Yeah, because he could get up there and literally say anything, because there's no documentation that they can be like, okay, but on page 5, you said this. They don't have anything that they can call him out with. Yeah, isn't that illegal? Like, there's a name for that. So wild. I know, every time, Lisa said, every time I want to cry, I just think about the singular eyebrow. The freaking singular eyebrow. I know. Let's go back. Let's go back again. The firefighter with the peg-legged firefighter that wears all black, wears a mask, carries a vacuum, and has one big bushy unibrow. Or he has no eyebrow because let's just say it got burnt off being a firefighter and he's just got one really big bushy eyebrow on that side. I just don't even know anymore. I am just... Someone needs to draw this. Somebody needs to go to AI. Was it Grok? Is it Grok over on Twitter? Somebody needs to use these descriptions and draw me what the hell Dylan is claiming that she saw. I want to see the photos from inside of her bedroom. I want to see the photos so bad because I don't remember seeing any pictures that showed anything like that. I want to see it so bad. I want to see it so bad. Okay, let's see where I was because this is just wild. Okay. In its expert rebuttal disclosures, the state provided a summary of Special Agent Valance's proposed testimony. Portions of the summary are in direct conflict with his previous PowerPoint disclosures, further complicating Mr. Kohberger's guesses as to what his testimony may be. So, whatever the state gave them that has, I guess, like points about what Valance is supposed to testify to, it conflicts completely with what is in his previous PowerPoint information. Well, then technically, I guess that's enough to call him out. Like, I agree that he doesn't have like reports and stuff, and he should have by now because Judge Hippler already said he wasn't playing games about any of that stuff either. Like, he seems to be a stickler, Hippler the stickler, right? So I don't know why that wouldn't be enough to be able to call him out on it, because I'm pretty positive they've got the proof of all of that. Like, they can show, you said this here, but that's not what this says. I mean, they've pretty much done that already, right? The 7 minutes. The 7 minutes, right? The 7 minutes. This is insane. Okay. Mr. Kohberger's expert, Cy-Ray, which is technical proof that all the people that have been thinking the whole time that Cy-Ray is off the case because Forensic Frenzy came out like a psychopath that she is and tried to claim that she has all this inside information and that Cy-Ray is not working on the case anymore, where this document is dated just a few days ago and Cy-Ray is still being listed as an expert. So I guess that gives us the answer to that. Cy-Ray's not going anywhere. Mr. Kohberger's expert, Cy-Ray, has conducted a detailed analysis of Special Agent Valance's PowerPoint and found severely flawed findings that are well outside of established and known best practices in the field. The PowerPoint is vague and makes it impossible to determine what Special Agent Valance is claiming. Thus, the additional summary does not remedy the lack of disclosure, leaving Mr. Kohberger in inability to prepare and meet the constitutional protection of confrontation. Testimony must be prohibited pursuant to Idaho Criminal Rule 16, Idaho Rules of Evidence, the court's scheduling order, and Mr. Kohberger's federal and state constitutional rights of a fair trial, confrontation, and due process. And I have a feeling that's going to be at the end of every single one of them. Yep. So I don't have to read the last sentence of all of these. Thank you for the $1.99 super sticker. I very much appreciate it. Isn't this wild stuff? Isn't this freaking insane? This is like the most interesting document that we've had in a long, long time. Just so insane. Now we have Mr. and Mrs. Barnhart. Who the frick is they? They're experts? It says no expert opinion has been disclosed, but who is Mr. and Mrs. Barnhart? Let me see if I can find anything. Expert witness? Hold on, I'm seeing if I can find anything. All I'm seeing is, oh, hold on a minute. Oh, look, this is funny. The only result, look, let me go back. The only result for Mr. and Mrs. Barnhart expert witness is this actual document. We've had that happen before whenever they fat fingered that one guy's name. Okay, let's go back to this one now. Oh, it went away. Hold on. That's funny. Okay, let's get rid of this stuff right here. So I don't know who they are, but this is all it shows me is anniversaries, obituaries, and like I said, it goes straight to this actual document that we're already reading it from. I don't know who that is, but they're experts of something. Okay. Testimony must exclude everything other than specifically disclosed, including purported habit evidence. habit evidence. So are these people that know him? Are these the neighbors that say that he was up vacuuming at 3 o'clock in the morning? Is that who this is? The state has not produced a report specifying what habits are referred to. No expert opinion has been disclosed. See, that's the part that I'm kind of like thrown off on. Because this sounds like they're people that might just like know him for habit purposes of how he like lives his daily life. But then it says no expert opinion. So who the frick is this? Mr. Kohberger cannot prepare to confront purported evidence against him that is not disclosed. And then there's that same sentence. Who the frick is this? Maybe. That's what I'm wondering. Like, is it the neighbors that hear him vacuuming all the time? I'm trying to see if I see anything else. Because, like, you'd think that, like, a case that these people have worked on before would pop up. Because you know how we have the Murder Sheet podcast as a married couple, and then we also have Defense Diaries. They're married. It might be the neighbor. Okay. Now this next one is for Amazon. Mr. Cox for Amazon. Testimony must be excluded because no opinions or full analysis of the data has been provided. It appears Mr. Cox has credentials to gather data on Amazon, but nothing disclosed indicates he has the expertise to form an opinion on data. And if he does have an opinion based on analysis, neither the analysis or opinion has been disclosed. The full amount of raw data received from Amazon has never been disclosed. So they don't even know. The defense hasn't gotten all of it, technically, then. Only narrow dates with some purchases have been disclosed. More than one? More than one. Despite warrants seeking very broad materials over the span of a year, and according to warrant returns produced. Excel spreadsheets, apparently relied on by the state, have redacted purchases without explanation. So the state only gave over the defense some redacted information about their own clients' purchases. I mean, if he wants to just prove whatever, he can just literally log into Amazon himself and pull it up. But instead of giving the defense these actual purchases they're trying to claim happened, everything that they handed over to them is redacted. Context for purchases at least 6 months prior to what has been provided are critical for drawing opinions. There is no full disclosure or analysis of clickstream history that spans the scope of the multiple warrants and subpoenas. So they went through for all the clicks and then they don't even have anything about all the clicks. There is no full Amazon advertising history, AI-driven recommendations, or cookies disclosed or analyzed. That's literally what they said that they had. Like, we just read that, and we're like, oh, they're only going for clicks because they've got literally nothing else. Clicks don't freaking matter. Stuff that you put in your cart and don't buy and take it back out don't freaking matter either. They're giving them nothing. The identification of the devices used is not disclosed or analyzed. No cart or wish list data is disclosed or analyzed. No omni-channel tracking data or platforms are disclosed and analyzed for a household where multiple members use the same Amazon account. So he must still be on his parents' Amazon account. Multiple people, 5 people at least, use that account. It's him, his 2 sisters, his mom and dad, and who knows who else has access to it. The search warrants request account-wide data, including linked accounts and device identifiers for a year spanned. That has not been produced, analyzed, or explained as an expert opinion. Mr. Kohberger cannot prepare to confront purported evidence against him that is undisclosed and lacks context. The state has produced a select portion of a whole record. The state has cherry-picked information. He cannot determine if the state is asserting a direct search or review of items algorithmically suggested through Amazon's ad system. Testimony must be prohibited pursuant to that same sentence. And then it says the subject matter of this testimony is challenged separately in the motion of limine number 15. I think that's one of the ones that we had seen previously in the unredacted version sealing thing, but I talked about all that stuff. I talked about all that stuff in that earlier video I did this morning. So they have nothing from Amazon. They have nothing from Amazon. And anything that was given to them is redacted. So did they freaking show the grand jury a bunch of redacted boo-boo too that has no information on it and say it was evidence? Is that what happened here? Exactly. The state should not have any undisclosed information. You found a Barnhart that's a doctor in Moscow, Idaho? Would he be going to a doctor in Moscow? I thought his doctor was in Pullman, or at least in Washington. I'm gonna have to look it up. This is wild. Yeah, this is what it sounds like. It sounds like whatever they did hand over, they have it completely redacted. I just don't get it. I don't understand how we got here. This is sick. Okay. Michael Douglas, the actor? I'm just kidding. Any opinion testimony must be excluded. All arguments set forth in Shane Cox in paragraph 4 above are incorporated for Michael Douglas as it relates to any testimony about Amazon or Amazon clicks. So he's an Amazon guy. The state intends to use, oh, no, he's a Fed. Okay. The state intends to use Agent Douglas as an Amazon expert without any explanation other than what a cherry-picked group of records might show. The state has produced some records and reports relating to documents collected by this witness. Not all raw data has been disclosed. No explanation of underlying raw data or how it was analyzed has been disclosed. The state has not produced a summary of an opinion without the purported meaning of such documents. Opinion testimony must be prohibited pursuant to, and there's that sentence again. So I'm trying to see what their problem is with this guy. The state wants to use him as an Amazon expert, but he's a Fed. Okay. There's no explanation for why they want to use this FBI agent as an Amazon expert. That should be a problem. And the only thing that they really have to show are these cherry-picked redacted records. So, yeah, he's a Fed. So they're choosing to use a federal agent with no reason, rhyme or reason, to pretend to be an Amazon expert. He cannot sit there and pretend to be an Amazon expert. That's false testimony from the second that he sits down. That's ridiculous. So number 6, various Idaho State laboratory expert witnesses are anticipated in trial. Yeah, I would freaking assume so. To the extent their opinions are limited to the reports authored by them and based on their own expert evaluation is not the subject of this motion in limine. This motion seeks an order preventing testimony outside of their reports. Testimony through any of these witnesses, other than their own opinions, stated in the Idaho State Police Forensics Laboratory reports, must be prohibited pursuant to the same sentence from forever. Now, remember, we do have Rylan Nolan. I think that's how you say it. Yeah, the next one right here. Rylan Nolan has been disclosed. Challenged to her proposed testimony is covered in a separate motion in limine number 6. Now, we heard from this person. We heard from this person in the grand jury transcripts. So I don't know what about her testimony that they didn't like. Because I believe all it was, yeah, somebody called the lab and asked what kind of trash would be good trash to grab from a trash pool that would have DNA on it. But they said that they didn't actually like do the call themselves, that it was just somebody in the lab, if I can remember correctly. Yeah, like you have to like say why you're an expert. Like if you're an Amazon expert, then I need to be hearing that you've worked for Amazon for 20 something years in the headquarters office and you know how to work this, that, and the third program. And you've helped secure programming updates. I need to know that you know what you're doing about Amazon. Just because you have a badge doesn't tell me anything whatsoever. Okay. Eric Seat, the expert opinion of this DNA technician provides an explanation of possible testimony regarding a methodology for DNA testing, YSTR testing, for which the defense has received no discovery or indication that the method has been used in this case. There is no opinion disclosed other than, because of the large volume of discovery, the state directs the defense to summary reports of the expert's ultimate conclusions, which which can be found in lab report number 3. Lab report 3, and then it gives the Bates number, is DNA data of an alternate suspect, but no ultimate opinion or result is specified. What? So they... What? I'm going to reread this because this sounds confusing. It sounds as if the state is telling them that the only thing this guy can talk about is about the Hold on. Let me reread this. There is no opinion disclosed other than, because of the large volume of discovery, the state directs the defense to summary reports of the experts' ultimate conclusions, which can be found in lab report number 3. But lab report number 3 is the DNA data of an alternate suspect. The state is telling the defense to only rely on the summary report that has nothing to do with Bryan, but everything to do with an alternative suspect. Am I hearing that? Am I reading that right? And the first footnote is motion in limine number 2 exhibit from the ISB lab report that it doesn't even matter. But that's what I'm hearing, right? Like, that's how I'm understanding it. The state is telling the defense that the only report that they need to rely on when it comes to Eric's seat has to do with alternate suspect DNA. What? Why in the frick would you tell the defense to rely on a report that has something to do with something other than the defendant, while also saying that you don't want anything about alternative or alternate perpetrators even being discussed? I'm confused too, broski. Hey, Bryan. Hey, Bri. Thanks for gifting a membership. Yes, it's very confusing, but I'm telling you, that's what it sounds like. I mean, I could be wrong. My brain is just my brain, and my brain is tired. But that's what it sounds like. It literally sounds like the state told the defense that when it comes to any sort of expert opinion from Eric's seat, the only lab report that they need to be worried about is number 3 that has nothing to do with Bryan and everything to do with an alternate suspect. How are we here? I'm just going to keep asking. How did we get here? How the frick did we get here? McDonald did not find that glove. The glove that had the DNA on it, on the inside of it, was found a good, like, 6-ish days before McDonald was even at the scene. So he lied to all his people about that damn glove. Tara gifted a membership. Thank you. Congratulations to whoever gets those 2 gifted memberships. This is just wild. I mean, I'm trying. I don't understand half of all this crap either. This is just so wild. So wild. Testimony through this witness, other than that relating to an alternate perpetrator, must be prohibited pursuant to, and then we have that sentence again. Wild. Wow. The only report you need to worry about when it comes to this DNA guy is the report we gave you that has nothing to do with your client. But you can't talk about anybody else being involved. Even though we're handing you the report with his information on it, with this person's information on it, you still can't talk about it. This is Delphi 2.0. What? Tell It to L had a quick video titled Kohberger Barnhart Family Ties. Who the frick is Cindy Barnhart? Well, what are y'all talking about? Okay, I'm going to look at that stuff up later. I'm not going to get distracted, but I'm going to go look. That's wild. That's wild. Okay. The next one, having to do with Maori, Tanzola, and Yorig. The state has provided no disclosure of any expert opinions related to 67 electronic devices and third-party data collected during the investigation. The state has failed to identify what portions of the electronic device data, digital data, and or third-party search warrant return data will be presented. The state has failed to disclose any expert opinion about what analysis of the devices and data depict. The state has disclosed in discovery a new report stating further examination is taking place. I'm sorry? Footnote 2. Motion in limine police report indicating additional analysis of Mr. Kohberger's computer. So what do they think they're going to freaking find that they didn't find the freaking first 2.5 years of this case? They've literally already stated that there's nothing there. So they're going back now and looking again. They're looking again. Welcome. Welcome, Little Har Oak. Little Har Oak. Welcome, welcome. Wow. Cindy's stepson used to live at 1122. Okay, see, now y'all are going to make me stay up all night. What? Yeah, I need to know who this is. After the live, I'm going to probably be up forever trying to find out all this information. I want to know who the Barnharts are. I'm surprised they allowed that name out here like that. Because the last name, that's all anybody needs. That's all anybody needs. I mean, Bri, how have we gotten to this point? With all of this insanity, what's happening? Yeah, I saw Grizzly did a live about it. I try to stay away from people that I adore's videos about cases that I cover. Because I don't want anybody to be like, this person said this or this person said that. I don't care. They can have their opinions. I love Grizz and I love Melissa Jade, so I don't go over there and look at what they're talking about. Mr. Barnhart resigned from WSU not long ago? Interessante. Damn. No. Angel. Are you serious? I know that name. Oh, buddy. I'm going to have a lot to look at. Okay. We're going to stop right now. Because I've got to figure all this out and put it together because now it's relevant. This name is relevant. Thank you so much for the $9.99, Hollyberry. I very much appreciate it. Holy crap. That's wild. Yeah, we're going to have to. Thank you for the $2, RV. Keep it rolling. I very much appreciate it. Thank you. Yeah, we got to get back to this. That's wild. I'm going to have to do all that stuff. Mr. and Mrs. Barnhart are apparently some sort of witnesses about habits. And that's about as far as it goes. But it says something about there being an expert opinion, but I can't find anything that labels them as any sort of like experts on anything. So we're thinking that they're people that actually like knew him, that knew Bryan. We're going to figure all that out. We're going to figure it all out. That's insane. Okay, now we're finding out that they are now running through his computer again, apparently. Which, again, I don't know what they freaking think they're going to find over 2 years later that they haven't already found. They've literally probably thrown every resource they have at his devices, and at this point, they've come up with literally nothing. Literally nothing. That disclosure came well after the state's discovery deadline. The report does not contain any sort of opinion. Recently, the state submitted rebuttal expert disclosures. Repeatedly, the state writes that it cannot provide rebuttal as Mr. Kohberger has not provided information about what his experts may say. The state's disclosure would seem to be the proverbial chicken and egg antidote, except in criminal proceedings, the accused has rights under the United States Constitution and the Idaho Constitution. No joke. I should go and get my eyebrows done and record it just for irony. I really should. Thank you so much, Danny, for the $5. I appreciate it. That's hilarious. This whole thing is just wild. This whole thing is just insane. Absolutely insane. Court proceedings are rule-bound and presiding judges pronounce deadlines. As such, the state was required to provide expert opinions to which Mr. Kohberger would rebut. The state's disclosures remain vague. Mr. Kohberger cannot prepare to confront purported evidence that is undisclosed. The electronic evidence in this case is critical, and the state is impeding the defense from being able to prepare to confront evidence or use evidence in Mr. Kohberger's capital trial. Testimony must be prohibited, and there's that sentence again. Okay, number 7 would be Detective Gilbertson. The state did not disclose Detective Gilbertson in their initial disclosures, but instead listed him as a rebuttal witness. The state did not identify. The state did not identify any specific expert or opinion that the detective will rebut. Thus, the court should exclude this testimony as outside the scope of rebuttal and irrelevant. Moreover, the court should exclude the testimony under 403B. The relevance of this testimony is minimal at best and carries a serious risk of juror confusion. The detective walked alone through a house that he is intimately familiar with in the middle of broad daylight more than 1 week after the house had been vacated and changed significantly due to a homicide investigation. Why does Gilbertson know the house intimately? Who the frick is Gilbertson? Exactly. Why does he know that house intimately? That's a wild statement. So this is Darren Gilbertson. I can't open this one page. It says that it's blocked, probably because I have a VPN on. He was dating the house, right? That's a wild statement. See, if I click right here, it just says something about Darren M. Gilbertson held multiple jobs between 2017 and 2023. One of the most recent is a police sergeant, but I can't click it because I don't have a login. This is like an employee thing. But it does talk about ISP. They spelt Kohberger's name wrong in this article on Facebook while having the title have it right. Wow, that's wild. That's wild to say that. That this detective had an intimate familiarity with the home. And he walked through it a week after it had been changed significantly. So I'm guessing like a week after like boards and stuff had been taken out, because we know they took out pieces of the house. That's a very wild statement, especially since he's with ISP and not Moscow Police Department. I want to know why the hell it says he's intimately involved with that house. That's wild to me. Thank you for the 5 gifted memberships, RVing. Keeping it rolling. Congratulations to the people that get the memberships. That's a wild statement. I'm gonna have to look up and see, like, did he used to live there? Did he date somebody who used to live there? Because it's a rental house. Interesting. He simply counted out loud upon entering rooms. What? So he walked through the house in the middle of the day and just counted out loud upon entering the bedrooms? What good is that? What good is that? I don't understand what you're doing. This is a far, far cry from what the state alleges occurred. Additionally, Mr. Kohberger attempted to learn more about the experiment through discovery. He sought things such as recordings or photographs of the timed run or written notes taken and documented during the experiment. Nothing was provided in discovery. So what did he do? Kind of like walk the scene the way that they thought that maybe the perpetrator did and like yell as he went into each room? Is that what he's talking about? Nothing was provided in discovery. The prosecution stated those items did not exist. So he just went through the house being crazy and he didn't like do anything with it. C exhibit number 2. No, C motion and limine number 2, exhibit 3, discovery request and response. This is defense 9th supplemental discovery request. Damn, that was a long time ago. Item 211 and states 8th supplemental discovery response, item 211. So he just ran through the house yelling and screaming like a weirdo for no reason? Finally, the court should exclude this testimony because it violates Mr. Kohberger's due process rights. The house has been torn down. The defense cannot now effectively rebut this inflammatory and minimally relevant testimony. I mean, this guy sounds like he wasn't really doing much of anything at all. Gary Dawson. This expert was disclosed for the first time in the state's rebuttal experts. He is a toxicology expert. Mr. Kohberger did not disclose an expert relating to toxicology. This expert is not a rebuttal expert and should be excluded from trial. I don't agree. I want to know what their freaking toxicology results were. I want the breakdown. I want the rundown, and not just of the victims, but of Bethany and Dylan too. I want it all. I want all of that information, especially since what was said in the very beginning from Mabbitt that she didn't think toxicology is going to matter. No, I think it's going to. David Middleman. This expert was disclosed as a rebuttal expert relating to IgG matters. This expert is addressed in a separate motion, which would be number 12. Then it goes down to, it is in the interest of fairness, justice, and judicial economy to exclude the listed experts. Late disclosed expert opinions do not allow the defense sufficient opportunity to conduct the follow-up investigation necessary and put the defense at a significant disadvantage. The state has turned over numerous generic responses identifying expert names, but only vaguely describing the subject matter that they will testify to. The disclosures do not identify the contents of the anticipated testimony, nor the documents or evidence that the expert relied on to reach that conclusion. As federal courts applying the analog federal criminal rule have held, a mere list of topics or general subject matter about which an expert witness may testify is not a discovery response that complies with the rule. The disclosure rules are not simply for case management purposes, but fundamental to a defendant's right to a fair trial. The rules are designed to promote fairness and candor, facilitate fair and expedient pretrial fact gathering, and prevent surprise at trial. Amendment to Federal Rule of Criminal Procedure 16. The amendment requiring the disclosure of expert opinion testimony is intended to minimize surprise that often results from unexpected expert testimony, reduce the need for continuances, and to provide the opponent with a fair opportunity to test the merits of the expert's testimony through focused cross-examination. These purposes are not accomplished by a generic discovery response of the type presented here. Other courts analyzing the analogous federal rules have explained why late disclosures are so prejudicial to the opposing party, even in the civil context, in which constitutional protections are far fewer than those guaranteed to criminal defendants. For example, in Churchill versus U.S., the trial court found that exclusion of several expert witnesses was necessary when one party complied with the court's expert disclosure deadline and one party provided only the names of experts and failed to provide detailed reports or opinions. Give me 1 second. My dog just popped my door right open. She had to potty. she comes in here and she looks at me a certain way, and I know that she has to go to the bathroom. So I had to go get the child, tell him to take the dogs out. Okay, where were we? We finished that sentence. Okay. The court found that simply reciting the names of the experts does not prevent surprise by the opponent, and specifically noted the prejudice that occurs when one party complies with the deadline and the other party does not, as in this case. The state's experts have had the benefit of being in a position to examine and rebut the opinions set forth by defendants' experts in their initial reports. This is a significant litigation advantage. The party who failed to comply with the deadline set forth several reasons why the defense was not prejudiced, but the court observed that forcing the innocent party to complete everything necessary on an expedited timeline was inherently prejudicial to their case. Even assuming all of the necessary investigation and preparation can be achieved in 6 weeks, an ambitious schedule to impose on defendant as the innocent party, there would be insufficient time for the court to hear and decide non-dispositive motions related to expert discovery before the dispositive motion filing deadline less than 1 month later on April 12th of 2011. And again, they're citing a whole other case. Thus, the cascade of time extensions will affect the deadline set for dispositive motions, the pretrial conference scheduled for July 6, 2011, and ultimately the trial, which is currently scheduled for August 2011, which, again, not this case. The court then noted the importance of parties complying with the scheduling order in good faith. Plaintiff's assumption that 6 months is sufficient time to revamp the scheduling order in this case to timely proceed to trial is mistaken and shows a fundamental misunderstanding of the purpose of the court's scheduling orders. The dates were not haphazardly selected or unrelated to the needs of the parties or the court. Instead, the scheduling order represented the best estimate of the court and counsel as to the agenda most suitable to dispose of this case. As the Ninth Circuit has made clear, disruption to the schedule of the court and other parties is not harmless. In these days of heavy caseloads, trial courts routinely set schedules and establish deadlines to foster the efficient treatment and resolution of cases. As the torrent of civil and criminal cases unleashed in recent years has threatened to inundate the federal courts, deliverance has been sought in the use of calendar management techniques. Rule 16 is an important component of those techniques. Thus, a scheduling order is not a frivolous piece of paper idly entered, which can be cavalierly disregarded by counsel without peril. Parties must understand that they will pay a price for failure to comply strictly with scheduling orders, and that failure to do so may properly support severe sanctions and exclusions of evidence. They're also talking to see Albert D. Sino, whatever, versus Aspen. Yeah, this is like a site number. Okay. Excluding witness because the report was not provided. There's not like a beginning sentence right here. This is written strange. I'm just going to start right here. Excluding witness because the report was not provided until almost 3 months after the deadline passed, depriving the opposing party of time it could have used to prepare accordingly and providing the disclosing party with a litigation advantage. And it states State versus Martinez from 2002. In Taylor versus Illinois, the United States Supreme Court stated that when the omission was willful and motivated by a desire to obtain a tactical advantage that would minimize the effectiveness of cross-examination and the ability to adduce rebuttal evidence, it would be entirely consistent with the purposes of the compulsory process clause to exclude the witness's testimony. The same analysis is applicable here and carries even more force. Mr. Kohberger is a capital defendant who is entitled to his day in court without undue delay by the prosecution. He is entitled to a heightened standard of reliability because prosecutors are seeking his execution. Prejudice is magnified in a criminal case when the state has the advantage of the defendant's expert disclosures in drafting their initial expert opinions. The state has the resources of dozens, if not hundreds, of people working on its behalf from various state and federal agencies. It has the advantage of technology that is available only to law enforcement agencies and not to the defense. It is bringing the full resources of the state of Idaho to bear alongside assistance from the federal government, while Mr. Kohberger has a defense team consisting of 3 attorneys, 1 investigator, and 1 mitigation specialist, who must not only review all of the state's evidence, but conduct an independent investigation into both the circumstances of the crime and into Mr. Kohberger's entire life history. The pre-existing resource disparity must be taken into account when assessing the additional tactical advantage that the state has improperly obtained. Notably, the state did not seek modification to the scheduling order to allow for a later disclosure deadline, which would have equally applied to the defense would not have given the prosecution a tactical advantage. It is fundamentally unfair for the state to shirk the court's order and reap the tactical advantage of being able to review the defense's expert opinions before making their initial disclosures, in addition to the already existing advantage in resources. The court should exclude the listed expert reports and evidence listed above and preclude the death penalty at trial in order to cure some measure of the prejudice to Mr. Kohberger. And that's it. It was signed on 2/24. So that's a little bit crazy that, again, they think that they can just like go and search some more stuff in his computer. What exactly do they think they're going to find? They've already looked. Whatever. Okay. Let's look at this one. This one's number 3. I'm not really quite sure how else to use the term that I can't even actually repeat too many times. Do the car one next. How far is the car one? We've got the M word, psychopath, sociopath, inconclusive data, eyebrow we did, click evidence, make and model of suspect vehicle. I gotta go in order. now, or else I'm gonna lose my mind. I only did the bushy eyebrow one because it was hilarious. I mean, not hilarious, but y'all get it. Let's go to this one. Now, I can't say the word because, I have to speak YouTubeese on YouTube. So I can only say it one time. And I'm going to say it in the title and then have to say, especially right here. They're trying to get everybody who's not smart kicked off YouTube. Look at this sentence. Okay. This is the motion in limine regarding the term murder. Comes now, Bryan C. Kohberger, by and through his attorneys of record, and hereby moves the court for an order prohibiting the use of the words weapon, and similar forms of the word word applied to Bryan Kohberger during the trial of this matter. This motion is not seeking a prohibition on the use of the word or its varying forms in the charging documentation, or jury instructions. This motion is made pursuant to ICR 47, IRE 403, 70102, the 5th, 6th, and 14th Amendments to the United States Constitution, and Article 1, Section 13 of the Idaho Constitution. Whether the killings at issue are it as allegedly committed by Bryan Kohberger or by an alternate suspect or someone still unknown is the ultimate issue. Each side will present this very argument to the jury. It is a matter of fact to be found by the jury after the court instructs the jury with the applicable instructions. To label Mr. Kohberger as an worder, the alleged weapon consistent with an empty sheath as the weapon, or to assert that any of the four decedents were M-worded by Mr. Kohberger denies his right to a fair trial and the right to be presumed innocent. IRE 403 allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply to terminology that is unfairly prejudicial. The use of the word M during the course of the trial is unfairly prejudicial in that it asserts a factual and legal conclusion of the evidence, a determination which is left to the jury. The prosecutor, law enforcement, and medical examiner are viewed with authority and respect by most jurors. When persons with authority speak, lay people tend to believe their statements and conclusions. If the prosecution or its witnesses use these words in its case in chief, it would improperly imply to the jury that it is the prosecutor or witness's belief or opinion that the defendant is guilty of M. This is improper opinion testimony under IRE 701-704. It is improper for the prosecution to express a personal belief unless the comment is based solely on inference. Expert testimony that concerns conclusions or opinions that the average juror is qualified to draw from the facts utilizing the juror's common sense and normal experience is inadmissible. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the words M-worded, M-weapon, as well as derivative forms of the word, that one. So ridiculous, isn't it? That I can't just freaking say it. Thank you, Holly Berry, and thank you for being a member for a whole year. A year is a long time. A year is a long time. Isn't this insane? But how do y'all feel about this one? Like, I know that they have to sit there and say that they believe that he's the one who did it. I mean, in the end, the entire argument on the state side is completely irrelevant if they can't prove that he was at the scene at the time that it happened. If they can't put him at the scene, besides that stupid touch DNA that could have literally been picked up from literally anywhere, it's all irrelevant if they can't actually put him there. Okay. Now we have, my dog just did it again. Hold on a second. She wants to be in here so bad, but I've got clean clothes on the bed and I cannot have her in here on my clean clothes. Okay, let's go through this one. This one is using the term psychopath or sociopath. This is interesting. It's probably going to follow the same vibe as the other one that we just went through. Oh, hold on a second. Okay. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves the court for an order prohibiting the state from name calling. Specifically, this motion seeks to bar the use of the terms psychopath and sociopath. The motion is made pursuant to ICR 47, IRE 403, 701-04, and the 5th, 6th, and 14th Amendments to the United States Constitution, Article 1, Section 13 of the Idaho Constitution. I'm pretty sure they use that exact same one in the other one too. IRE 403 allows exclusion of evidence that is unfairly prejudicial to a party. By analogy, the same principle should apply to terminology that is unfairly prejudicial. The use of the word psychopath or sociopath during the course of the trial is unfairly prejudicial. See attached affidavit from Dr. John Edens. Well, who is you? So there's a few. There's a John F. Edens from, well, this one's about the psychology and the brain, but there's one that's coming out of Texas A&M University, and then there's another one coming from Palo Alto. See, and this tells me that there must be something in Bryan's mental health history to where these things were maybe listed. So let me ask you guys while I have you guys in here, because I'm going to ask this question. I mean, I asked this question, I guess, in my community tab, but I want to see what you guys think about this while I have you guys live for a second. Let me get rid of this for a minute. I don't remember if I asked this already. I don't think I asked this already. What do y'all think about Tapatalk? What do you guys feel about the Tapatalk posts? Do you guys think that it's him? I believe that the Tapatalk post where he talks about his visual snow and all those things, I think that it's him. And I say that because the last active date was in 2012, and for somebody to have logged in and changed the username and the profile picture to be Bryan Kohberger stuff, it would have shown a last active date of sometime probably after he was arrested. Like it would have like a 2022 date. But it doesn't. It has November of 2012, I think, as the last active date, which meant that like it wasn't even logged into since then. Yeah, the EXARR, yeah. And there's a Yahoo email address that matches that. Yeah, I mean, I agree that a bunch of, teenagers have dark thoughts and stuff, but this kind of goes along with what they're kind of trying to say, to where just because Bryan might have some like mental health issues, it's completely irrelevant because nothing puts him at the crime. And according to the evidence, he's innocent. But if you come out here talking about his mental health history and the issues that he has, psychologically, when it has nothing to do whatsoever with the crime itself, because you can't prove that he did this, it puts on that negative, you know what I mean? Like it puts that negative of him. The picture is him, Tara. If you go back and look at the testimony not testimony because she wasn't in court, but the girl that went to school with him, that hung out with him before his H issue, they did a bunch of FaceTimes and videos and stuff together, and she had screenshots of Bryan from back in the day whenever he was young and had no facial hair at all and a smooth face and a short haircut. That's him. It's him. You can go back and you can look in those things. He's in the exact same room. It's the wooden wall, the exact same room. It's the exact same types of shirts that he always wore. It's him. And if somebody would have logged in, it would show the last active date not being over a decade ago. The Yahoo email address is not on Tapatalk. We've just seen certain things that show that there is an old email address from Yahoo that uses that exact same thing. And since it's old and inactive, for it to have been over a decade ago, it makes a lot of sense to me. And like I said, it wasn't active since 2012. So for somebody to have logged in, changed the profile picture, and changed the name, it would have shown that it was active, and it doesn't. I mean, we've talked about the email addresses before, Tara. You can go back and look at the other videos. But we've gone through all those already. But the proof is the proof is the proof that if the last active status was in 2012, nobody in 2022 logged in and changed the information, because it would show that the last account status was 2012. I mean, was not 2012. It would show 22. That's kind of like the whole point. I mean, not really. I'm not going to sit here and argue with you just personally. I have my own beliefs, and I believe the technical data is not going to lie. If it says it hasn't been active since 2012, nobody logged in 10 years later and updated Bryan Kohberger's profile picture an email address name to that account, it would show last active in 2022. And it doesn't. And it actually doesn't. But it would relate to this sort of situation because, like I've said from the beginning, no matter how I feel about the case facts, a teenager doesn't just jump into an addiction that severe without there being like stepping steps into that kind of addiction. And according to everyone that we have heard from that knew Bryan from back then in school, there wasn't a lead up. He just like jumped in and did the craziest thing that anybody possibly could have done. I don't know how. So I don't know. I don't know what the issue is. But again, for there to be some sort of affidavit from a doctor and then not wanting certain words said, it does make me feel like maybe Bryan does have some mental health issues. Who freaking doesn't? Who freaking doesn't? Pretty much everybody does. I don't know anybody who doesn't have something. I mean, yeah, I asked for an opinion, but I'm giving my opinion and you're like barking for me to show you proof whenever I just barely brought up something last minute because it was on my mind. Plus, we've gone over all those emails and stuff already. Tapatalk is just like a Reddit, I guess, where they have like forums where people can go in and talk about certain things. But there's an old account. You know what? Let me just pull the freaking thing up. I'll show y'all right now. I will show y'all right now. Because I've debated if I want to go through these on the channel. So this is Tapatalk. Let me make this smaller. This is Tapatalk. Now, this is Bryan. You can take this and you can look at it. You can compare it to the photos that we have from whenever he was a teenager that he had posted himself. That the one girl that Willie also knows also had of him that she shared on social media. It's him. That's freaking Bryan Kohberger. Okay. This is what I'm talking about here. Okay. Last active February 20th of 2012. If somebody would have logged into this account to change this profile picture and change this username, this would not say last active in 2012. This would say last active sometime after the time that his name was given out to the public. This wouldn't have a last active date of 13 years ago. That's why I believe it's him. And this document right here stating that there is a doctor that's going to be filing or has filed an affidavit, and now they don't want certain words that might be associated with maybe, let's say, the diagnoses in that affidavit. Maybe they don't want those words spoken out loud in court because at the end of the day, it doesn't have anything to do with Bryan because they can't place him there. And if they can't place him there, then it doesn't matter if he's a sociopath or a psychopath that's found a way to cope with things, or somebody with autism, or somebody with this tendency or that tendency. If they can't put him there and prove that he physically did the crime, then him having any sort of mental illness does not matter. So they can go on and on all they want to. But if they can't put him at the scene, it doesn't matter, which is why they don't want people saying these words in court. It makes sense. In the end, it does make sense. This is improper opinion testimony under IRE 701 and 704. Neither term is a proper diagnosis and is unequivocally unfairly prejudicial. Mr. Kohberger requests an order prohibiting the lawyers and witnesses from using the words psychopath and sociopath. Yeah, because if they can't place him, then it's pointless. Completely pointless. Okay. Number 5, inconclusive data. This was only 5 pages. That's not bad. Okay. Yeah, that's it. Motion in limine number 5 for inconclusive data. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby moves the court for an order limiting testimony about the statistical analysis of item Q13.1 fingernail scrapings. Okay. This is gonna, I need to read this. Is this not the same number that they used when they talked about the other profile? It was Q something. Yeah, I've been wondering for a long time if they had anything from fingernail scrapings. Okay, I need to find out why this matters, because they've been saying the whole time the only thing they have when it comes to the profile that they were working on towards Bryan was the knife sheath. And we follow the evidence no matter where the evidence leads. That's what everybody in this needs to remember. So we're about to find out. Okay? Allowing such testimony would violate Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. The motion is based on the 5th, 6th, and 14th Amendments to the United States Constitution, Idaho Constitution Article 1, Section 13, and Idaho Criminal Rule 16, and Idaho Rules of Evidence 102, 04, 701, 02, and 03. The requested limits are made to secure fairness in administration to the end the truth may be ascertained and proceedings justly determined. Further, the above requested matters are ripe for consideration by the court pursuant to IRE 104 based on the existence of issues that involve preliminary questions of admissibility. Statement of facts. Okay, I don't like how a lot of this is like. In grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings of Madison Mogen. The data consisted of 3-person mixture. Okay. The statistic, the likelihood ratio, was calculated assuming that MM was a contributor to her own fingernails. And whatever was testified to is freaking blacked out. The data from that sample was blank as to Mr. Kohberger. Blank what? What was it? I need this clarified. Grand jury transcript at 365 and 66. Miller testified that inconclusive means that an analyst is blank. Miller went on to explain that the likelihood ratio for Mr. Kohberger is blank. What does this mean? What does this freaking mean? I mean, I know that the defense is not going to file something that's going to make their client look guilty. At least they're not so freaking supposed to. But this is interesting because why the hell is it all blacked out? Like, why are they even allowed to put anything about the grand jury transcript in here if they can't just put it in here? Oh my God. This doesn't help us figure out anything. What does this freaking say? I'm going to read this again. See, exactly. If there's no proof against Bryan and these fingernail clippings also have nothing to freaking do with Bryan, why are we talking about him? Why are we talking about it? The grand jury testimony, Jade Miller testified as to the results of testing done on item Q13.1, a swab of the left fingernail clippings from Madison Mogen. The data consisted of 3-person mixture. The statistic, the likelihood ratio, was calculated assuming that Madison was a contributor to her own fingernails. But what does that mean, assuming? That they didn't test it to see and make sure? I mean, obviously, if you're scraping somebody's fingernails, you're most likely getting their own DNA. But what if you weren't? What if there was actually 3 and one of them wasn't Maddie. I'm hoping that they actually went through and tested that because that's wild. Okay. Miller testified that Maddie Mogen as followed, blanked out. The data from that sample was blank as to Mr. Kohberger. Miller testified that inconclusive means that an analyst blank, 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 blankety blank. Miller went on to explain that the likelihood ratio for Mr. Kohberger blank. This doesn't answer anything and makes things a little bit confusing. Argument. The use of misleading language confuses and misleads the finder of fact and is barred by the rules 402, 403, as well as due process in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. Okay, so just reading that tells me that this information being brought up at the grand jury regarding Mr. Kohberger's guilt or innocence should not have been brought up because it's irrelevant to Kohberger. That's how I'm reading this. Here, expanding beyond the language of the report would prejudice Mr. Kohberger in that it might allow the jury to infer that the inconclusive data would mean that he might be included. And they're saying that's not the case. That's why this is prejudicial and irrelevant and technically dangerous if it's not true whatsoever. The LR is a comparison of hypotheses. It is not a statement of identity or probability of identity. It simply asks the question, given the data, which hypothesis tested is more likely? For item Q13.1, both hypotheses tested for each individual assumed that Madison Mogen's DNA was present. So when the lab generated an LR laid out above, the hypothesis tested were. So there's no actual conclusions to this. Is there no conclusions to this? The guesswork was Maddie, Kaylee, and one other person, or Maddie and two other people. So you've got the possibility of two unknown DNAs under Maddie's fingernails, and you've got all these unknown male blood samples of stuff in the house, and we're still at a hypothesis. They better tell me at the end of this they have a freaking answer, because that's not enough. You didn't even take that all the way to the conclusion. How do you not take that all the way to conclusion? This comparison was done of all of the individuals listed in report number 7 and for Mr. Kohberger in report number 26. And there's a footnote. The motion in limine exhibit 1 for the ISP lab reports 7 and 26. Okay. At the ISP lab, any number greater than 100 is considered a conclusive result indicating conclusion. Any number less than 0.01 is considered a conclusive result indicating exclusion. Thus, if an LR falls within the range of 0.01 to 100, the lab cannot draw any conclusions and the data is reported as inconclusive. In her testimony, Miller did not provide a full context to the analysis. The lab reported a series of LRs for item 13.1 included an LR of 0.399 for blank, 0.48 for blank, 0.20 for blank, 0.2033 for blank. So that means that there's 1, 2, 3, 4. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the LR is exclusionary, but falls in the range of inconclusive. But is that trying to... Okay, see, that's even more confusing, because if they took... That's wild. So if they took clippings... Right? That's what I was just saying. Because this says Maddie Mogen, Kaylee, and one other person, or Maddie and two other people. But there's 4 freaking names right here. But what I'm trying to figure out is if they're trying to say that. See, I'm so confused right now. Are they trying to say that his DNA was on her hand at all? Because there could easily be a situation where she somehow got his DNA on her hand somehow. Same way that we talk about transfer and touch DNA whenever you go to a store, this, that, whatever. And that the knife sheath was hers, or she is the one who actually utilized the knife sheath. So her DNA could be, if this is what they're claiming, it wouldn't be too out of the realm for it to have then transferred onto her opening the K-bar. This is confusing to me. They're saying it's irrelevant, it's prejudicial. Who the hell are these 4 people? This part right here is where I'm confused. All of these individuals sit in the same shoes as Mr. Kohberger, namely that the LR is exclusionary but falls into the range of inconclusive. So that all these people have the same amounts of all of these individuals sit in the same shoes as Mr. Kohberger, the LR is exclusionary but falls in the range of inclusive. Of interest is when LR was blank. Okay, just a bunch of blanks. This Mr. Bird LR is similar to almost other LR and focusing on the inclusive LR mislead jury. And that implies LR means that Mr. Kohberger might in a sample. That's what I'm trying to figure out. Mr. Kohberger has disclosed that through further independent laboratory testing, okay, see, freaking out for nothing, he is eliminated as a contributor to item 13.1. See, that's why it shouldn't be on there. Is it mumbled? Well, we have a storm coming in, so maybe that's why it's acting up. Is it better now? Echoing. I haven't touched anything. It's better now? I did notice that like it glitched or something up here on the screen. We have like it's hella windy. It's been windy really bad. We've had like high wind warning since yesterday. Had to bring in a bunch of my like metal artwork and stuff that I had out there, so it could have been that. But this is confusing to me. See, that's what it sounds like it's trying to say up here. It's trying to that's what this was making it sound like, that his DNA was under her fingernails. But then if you go down here, it says that through further testing, they've proven that that's not true. So I wonder if there's a possibility that the sample from the knife sheath could have gotten mixed up with her hand samples? Because further testing proves he's eliminated. If I would have just read that first, I wouldn't have had a whole panic attack. But Mr. Kohberger sought to overturn the grand jury indictment. He argued that Miller's testimony was inadmissible and misleading. The state argued that the testimony was presented to the grand jury as exculpatory and an effort to elicit favorable evidence for Mr. Kohberger. So this exact testimony is technically exculpatory. See, the way they had it worded was tripping me out, because that's definitely not how it freaking wanted to sound for there, for a second there. The independent lab testing conducted by the defense related to item 13.1 is indeed exculpatory. That is not the indeed they were supposed to use. Mr. Kohberger is excluded, and the state should be precluded from misleading the jury in any way. A fair trial is mandated by Mr. Kohberger's federal and state constitutional rights to due process, a fair trial, effective assistance of counsel, and confrontation of witnesses. United States Constitution amendments, and I am not good with Roman numerals, and then all the rest of the sections they always talk about. Expert testimony improperly elicited must be excluded. And this one's signed by Vicka Barlow. Is this her first document that she signed as official lawyer person? Official, what you call it? You know what I mean? Is this the first one that she signed? That's pretty cool. But yeah, this whole thing right here was really confusing and really did make it sound as if they were trying to say that his freaking fingernails, like that Maddie's fingernails, had Bryan Kohberger's DNA under them. Now, see, there's going to be people that take this, and regardless that it says all these things down here about how he was eliminated, that it's exculpatory, that they have all this stuff that's favorable to him when it comes to these results, they're not gonna read that part. They're going to take the part that we were initially like, what the hell? And they're going to run with that without using the conclusion to this. That's what's going to happen to this. Yeah, they lied and gave a bunch of false testimony to make it sound as if it was about something when it's not about nothing. That's wild. That's absolutely insane. Okay, what's next? Let's see. The Rylan Nolan. Is it Nowland? Nolan, Nowlin? Rylene Nowlin in reference to touch and contact DNA. This one's 12 pages. This one might be the last one. We shall see. We shall see. Give me 1 second. Do y'all want to do the car one? Angel's not going to let up. We'll skip it. We'll skip around. We skipped around for Bushy eyebrow. What was it? Peg leg firefighter that wears black with bushy eyebrow. 1. Let's look at the car one. We'll just have to remember, I'll write it down, that we stopped and need to do number 6 because this will probably be, this one's only 4 pages. Yeah. If they're literally doing, if they're trying to reference the car with the sunroof, then we've got to see this. We've got to see this. Okay. Motion in Limine, number 12. Make and model of suspect vehicle. Comes now Bryan C. Kohberger by and through his attorneys of record and hereby move this honorable court to exclude at trial testimony by any state witness as to the make and model of the vehicle seen on the 1112 King Road surveillance footage. This motion is made pursuant to IRE 103, 104, 401, 402, 403, and 702, and further based upon Mr. Kohberger's rights. I know not. I don't know if that has a sunroof, Angel. I don't know if that's got a sunroof. We'll look at it more in just a second. Under the United States Constitution, 5th, 6th, and 14th Amendments, and Article 1, Section 13 of the Idaho Constitution. Pursuant to IRE 103 and 104, this court is required to the extent possible to limit a jury's exposure to inadmissible evidence. The state has claimed in various filings and reports that a FBI forensic examiner, Anthony Emel, identified the make and model of this vehicle seen driving in the area of 1122 King Road in the early morning hours of November 13th of 2022. The state has referred this to suspect vehicle number 1. The vehicle was not identified from surveillance footage in the area of 1122 King Road. The surveillance footage comes from a residence at 1112. So this is going to be like this is going to be like official. This is going to be official. For the first time, we're finally getting what we've been asking for, and now we're seeing why they never gave it to us. Okay. The surveillance footage comes from a residence at 1112 King Road. It depicts the corner of King and Queen Roads and to the house with the camera. From the footage, lights from vehicles can be seen on Walenta Road, a north-south roadway next to the neighborhood. Okay, let's zoom this in. Yeah, I don't see a sunroof. I see this being the windshield and the headlights being way in the way. This would be like the back window area. Yeah, this isn't the sunroof. This is the windshield. Now, you see this right here? Where's Heather? Where's Heather? I don't know if she's still in here. This thing right here bothers me because when we were talking about the dominoes possibility with well, and see, I don't know. I don't know if that's what that is. Because remember we went through the footage from Linda Lane of the car and it looked like it had like a placard on the top of it like it was a delivery driver. And I see a bump. I don't know if I can make this any bigger. I've already like exhausted my zooming. It won't let me go any bigger. No. Well, around here, Domino's has their own vehicles and they have little thingy-mabobbers on them. I can't zoom anymore with StreamYard. I'd have to be on a different thingy. So I see like a little black spot like at the top of the roof area right here, but I also see like this bump thing. That's why I'm like, could it be the car that we saw in Linda Lane that had like the sign on the top? But this would probably be why they didn't even care about the front license plate being part of the bolo until after they had Bryan's name, because if it was like this the whole time with the lights in the way, they couldn't tell either way when it came to a front license plate. Let's look at this next one. So this next one is the car leaving. Oh, what was the time on this? The time on this one is 3:56. This is the 420 speed off. This is the 420 speed off. So what you're seeing right here is the backlight. And you're barely seeing it. Like, why are they putting this even in here, guys? Why is this even in here? This is like hard to even tell what the hell they're trying to show. Like, I see lights right here and sort of lights right here. But this car is like driving and you're looking at whatever you're looking at through the wiring on the gate. Yeah, look, like this is just like you seeing like the lights, the backlights. You can't even tell what the shit this is right here. These photos are from 1112 King Road camera. Special agent email did not make a vehicle identification. Special agent Amel did not make a vehicle identification was not made from this footage. That sentence is all kinds of cracked out. Rather, as noted in emails between Mr. Amel and FBI Special Agent Edward Jacobson, it is clear that the identification of the make and model of the vehicle in this video was made via a separate video taken at 1125 Ridge Road. But see, okay, oh, look, it does say it right here. So, Judge Hippler tried to say that there was nothing in his freaking order, in his damn order. See, I'm going to have to go back in his order and prove him a liar on like 5 things so far, just that my brain is remembering. In his freaking order, he stated that there was nothing at all labeled Ridge Road when it came to what they were claiming this was. But literally, you can see right here in the attachments, everything is labeled Ridge Road and has the freaking address in it. What's 451 Paradise? Is that another address? I want to know. It's a house in Moscow, Idaho. Hold on, I got to get to Google Maps so I can show y'all. Maps. Okay, so there's Walenta. This is Paradise. So I'm going to assume this house. I've seen this house. I feel like I've seen this house going through these streets before. Because that looks hella familiar. Yeah, I feel like I've seen this. I've seen this going through this stuff before. We'll have to do some more digging on that address, because that's interesting. So there must be something there when it comes to steals and nothing was correct. And then they finally get to 1125 Ridge Road screenshots and are like, got a great one. And that's where it's apparently coming from. There is no continuous footage linking the vehicle at 1112 King Road footage and that from Ridge Road. Additional surveillance footage depicts vehicles, but not identifiable vehicles. Thus, labeling the cars from various bits of footage as the same vehicle is speculative. Mr. Kohberger seeks an order prohibiting the state linking vehicle identification to the make and model of the vehicle in the 1112 King Road video based on identification of the car at 1125 Ridge Road and referring to the vehicle as suspect vehicle 1. The speculative nature of testifying that the vehicle is the same vehicle renders it irrelevant to these proceedings, far more unfairly prejudicial than probative. Is what they probably meant to say. This is also a jury question, and testimony calling the two vehicles the same invades the province of the jury. Thus, this court should exclude testimony linking the two vehicles as the same. Well, it would help a lot more if they included a Ridge Road screenshot. This looks like a circle. This is confusing, though. See, like the little spot where people are like, oh, that's the corner of the sunroof. If you could see it. You know what? Let me see. Can I put this in here? I'm going to drop this in here so that you guys can open it if you want. This is the document. But it looks like there's like a circle. Like, oh, it doesn't show you. Okay, can I draw? Okay. Right here, there's like a circle. Okay. Let me see if I can. Okay. And then like right here, like this is the roof. But there's like a bump that goes like this right here. And it looks a lot like the car from Linda Lane that Heather found whenever we were talking about the Domino's thing with Ethan and Xana. That bump piece. But this right here is definitely a windshield. Like this is the windshield. This is like the side windows. This is like that line in like the car design, I guess. Damn, this thing is blurry. Here's this bump right here. No wonder they never showed us. That's crack. And see, and the way that this lines up is also like weird too. Because see, you see the lights. Oh, you see the lights right here. Like the backlights, because this is the 420 of the car apparently like speeding out, right? But then like the major other light is like over here, and that doesn't look right. Like this looks like this is the fire. This is the tire wheel. You can sort of see like a black circle, like where the tire is. So to me, the light should be coming out like closer to this, but it's all the way over there. Maybe that's wrong. Maybe more like that. It's interesting. That's for sure. But I don't disagree with this either, because they've said forever now that it's like a bunch of cut and pasted, edited footage. Like none of it tracks and goes like an actual path. That's wild. How funkated. It does look very distorted. It is a bunch of boo-boo. It's absolutely stupid. That's wild. I don't know if this is where we should stop. This one's 12 pages. Ooh, there's diagrams. What number are we on? This will be 6. Yeah, we'll probably go ahead and go through this one. But this will probably be the last one. And then we'll continue tomorrow. I'll probably jump on at like 6:30 or 7-ish. And we'll probably go to like 10 so that we can try to get through the rest of them. As long as they're not this long, we probably should be able to get through the majority of them. So this one is the motion in limine from Rilene Nowlin in reference to touch and contact DNA. Comes now Bryan C. Kohberger, by and through his attorneys of record and pursuant to the Idaho Rules of Evidence, moves this honorable court for an order in limine excluding the testimony of Rilene Nowlin and any testimony referencing the terms touch or contact DNA. Is it because a jury of people that aren't going to understand it are going to mean that they think that that means Bryan and the person actually did have touch contact, which isn't actually what that means? Is that what that means? It sounds like that's what that means. But no, the government has indicated that these terms will be used at trial. In Exhibit S21, the disclosure for witness Rilene Nowlin, the government stated that Ms. Nowlin would testify about general topics, including what is labeled as touch DNA. Okay, well, because it's nothingness. It's like dead skin cells. Or 2, purporting to be an opinion of the means or mechanism for DNA being placed on the sheath by any witness called to testify about DNA. Both the term touch or contact DNA or any opinion regarding how DNA ends up on an item is misleading in that it assumes facts that must be proven, would be confusing to the jury, and waste substantial time in debunking the testimony of an expert that is outside the purview of the field expertise and qualifications. Furthermore, the opinions of this expert has not been disclosed to Mr. Kohberger. As set forth below, the how and when of DNA arrives on an object cannot be scientifically determined and is not the proper subject of expert testimony. I'm going to disagree. Lucas Anderson. They were able to figure out, for those of you who have not heard that before, Lucas Anderson was a homeless man who was charged and sat in jail for a little over 6 months for the murder of a very wealthy man whose home was broken into by several people. And Lucas Anderson's DNA was in fact found under the fingernails of the murdered man. They were able to tell exactly how it transferred. It just so happens Lucas Anderson was wasted and passed out on the floor of a convenience store. 911 was called and an ambulance came to pick him up and put him in the hospital. That exact same ambulance then responded to the murder scene. That exact same ambulance that took Lucas Anderson's body from the convenience store to the hospital took the murdered victim from the house to wherever they brought the body. I don't know where they brought the body, to wherever they brought the body. Lucas Anderson's DNA was put under that man's fingernails because they shared an ambulance. And that doesn't make a lot of sense to me because I always thought that hands are bagged and like tied up so that those kinds of things like don't happen. But that's the story. Several people were convicted of that crime. And yeah, you can say, but he had an alibi, but Detective Mowry, he confessed. Lucas Anderson confessed. He said that he was always so blacked out that he thought maybe he actually did it, and he confessed. And then they found out the truth. So we can't sit here and say that DNA and how it got on an object cannot be scientifically determined. People can figure it out. People can figure it out. And if they tracked people well enough, they probably could figure it out. I mean, seriously, every little movement that we make, every breath that we breathe is tracked. So them trying to say that they can't figure stuff out is a damn lie. The use of this language confuses and misleads the finder of fact and is barred by the rules 402 and 403, as well as due process, in that the evidence is overly prejudicial. The erroneous admission of irrelevant and prejudicial evidence will offend due process when it renders a trial fundamentally unfair. Relevant facts. A knife sheath that was recovered tucked under the covers next to Miss Mogen at 1122 King Road, Moscow, Idaho, on November 13th of 2022. We have a footnote. This is an interesting footnote. I can already tell by reading the first couple of words. I want it to be like big enough for you guys to be able to see, but then it like goes over a little bit. This is stupid. Okay. The exact location of the sheath is unclear in both photographs of the room and in written description of its location. The body cam footage of one of the first officers on scene shows the sheath tucked under the covers next to Mrs. Mogen. Tucked under the covers next to her. Was she under the blanket? Yeah, if it was tucked, how did they see it? And why are they saying that it's noticeable, like on the first responding officers thing, whenever we're trying to, well, I guess that's sort of what Blaker's PCA alludes to, but then we have Payne acting like he's like the person who actually found it. Yeah, I mean, it very well could be for her own protection. See, yeah, y'all both said the exact same thing. No, her blood was on it. They finally came out and said that. Well, they said blood was on it. A few documents back, they finally did say that. No, and that's something I have always wondered, like, what clothes were they in? I've always wondered that, what clothes they were in. So that's interesting. Okay. The sheath was tested using standard DNA STR methods by the Idaho State Police Lab. Item, there it is, Q1.1. A swab from the sheath resulted in a single source male profile. And then we have the third footnote. While item Q1.1 was tested for DNA, it was never subjected to standard biological testing for the presence of blood or saliva. In one exchange of emails, Ryland Nowlin described the swabbing as being of the leather strap and internal metal area of the snap. The snap itself may not have been swabbed at all for DNA. The defense has no ability to retest based on the fingerprint process of the sheath, which is what they told us before, that the testing for fingerprints and DNA, what did they say? Did they say that they did the fingerprints first? Or was it after? I'm not going to pretend like I remember what was said, but I know that like the way that one of them was tested for very much decided how the other test would go. And to me, it would mean swabbing for DNA could manipulate a fingerprint or wipe off a fingerprint. That's what I thought after. That would make the most sense. That'd make the most sense. So because everything was already swabbed and then the fingerprint stuff was done, there's no way for them to go back in and try to swab or do anything with it anyway, which we've already known that there was like no way for them to be able to redo the testing. Literally at all. This profile was uploaded to the CODIS DNA database and resulted in no hits to known offenders. In its disclosures, the government has indicated that Ryleen Nowlin from the ISB lab will testify as follows. Well, we've got a fourth footnote first from up in CODIS. The other two male profiles identified in the ISP lab report as unknown B and D were never run through CODIS or subjected to IgG testing. The defense has never received an explanation as to why these two male profiles were not further investigated. And this is something that we need to remember, that Payne messed up, slipped up, and said that the reason why the unknown male profiles were never tested was technically like two reasons. One, they already had Bryan's information, and so they were like, we'll get to it later if we have to. We have to tunnel vision this guy first. And two, they're trying to make some weird ass excuse that if they were to file these other DNA profiles into CODIS, that it would bump out Bryan's. Well, you've already run it through CODIS. You've already gotten everything from CODIS that you can from that knife sheath DNA. So if it's already told you no hits, no results, why can't you load the next one in there? I don't really quite understand why that was his reasoning. That shit didn't make any sense. And nothing that I looked up in like the CODIS handbooks, the instructions, all of the things that are trying to like describe the way that the CODIS stuff actually works, none of it says you can only load in one at a time. That doesn't make sense to me. Why they're trying to say you can only do one at a time. Now, this is what they're claiming that Nowlin is going to testify to. Miss Nowlin will also testify to touch DNA and transfer of DNA. Specifically, Nowlin will testify to the characteristics and nature of touch DNA, including how it is deposited and transferred to an item of evidence. But they just said up here that you cannot scientifically figure that out. Make up your mind. Make up your mind. The methods used to collect and preserve touch DNA samples from items of evidence, the procedures and protocols used by forensic scientists to extract and analyze touch DNA, the manner in which results from touch DNA samples are interpreted, the reliability of touch DNA analysis, and its acceptability in the field of forensic science. Nowlin will also testify to the potential for DNA to transfer between an individual and an object, including the distinction between primary and secondary transfer and the factors influencing the likelihood of transfer. I don't see anything wrong, because it can be so freaking innocent, but I get the point, I guess. On February 17th of 2025, the state produced a second round of disclosures, including one from Riley Nowlin, Exhibit S11. As with the first disclosures, the focus of this second disclosure is touch/contact DNA and direct versus indirect transfer. Although conceding that currently DNA technology cannot conclusively answer the question, the state offers the following opinion. Many complicated factors can influence the likelihood of transfer of DNA and the persistence of the transferred DNA after deposition. Deposition? I feel like that should be I mean, it's probably the word that they're using for deposit, but something just tells me that's weird. Okay. Current DNA technology cannot conclusively answer the question of when DNA was deposited on an item or by what mechanism, but that's not technically true. It is possible the DNA detected on M2022-4843 item 1.1 resulted from secondary transfer. However, based on Nowlin's training and experience, it is her opinion, given the quantity of DNA detected on this item, which is like nothing, and given the DNA profile obtained is single source, it is more likely the result of a direct transfer. Highly unlikely. Argument. Introduction to the concept of touch DNA and transfer opinion. So this is where we're going to get schooled, I guess. Well, Richie Rich says, I don't think Bethany was in the house at all. That's why the two girls were texting each other. I'm bringing this one up because they've said in the documents that we've read tonight that Bethany was asleep, or they both fell asleep. Dylan called Bethany's phone, then went downstairs. Both the girls fell asleep is what they're trying to say. Hey, faux pair. That's what they're trying to say. I know a lot of people don't think she was there. A lot of people don't think that she was there, but that's what they're claiming. The terms touch and contact DNA came into use as the forensic community shifted from the testing of obvious identifiable stains, such as blood or man stuff, to samples that can be identified via a biological test based on the increasing sensitivity of DNA test. Samples such as swabs from steering wheels of a carjacked vehicle or window jams in a burglary were collected and tested in the theory that a person would have been in contact, probably should have been what that says, with the object and left DNA behind in the form of skin or other cells. Hence the term touch or contact. the forensic community began to conduct research into the question of how DNA in the form of biological material moves in the environment, and this research led to the conclusion that it is impossible to determine how a particular deposit of DNA came to be on an object. In 2013, an article which reviewed the state of the research at the time made the following conclusions. Well, I really wish they weren't referencing something from over a decade ago, because there's been a lot of changes since then. I feel like they probably could have done better. Full DNA profiles can be recovered from items that have not been touched, but have been in the vicinity of someone speaking or coughing. Yeah, we actually went through a video where it showed, it was like, what was it, the milk jug one? There was like a bunch of people's DNA all over it, and they hadn't even been anywhere. Like, basically, you can go to Starbucks, get a coffee, and you can have the DNA on your hand, on your cup of a person who maybe got coffee right before you and went to a store and used a pin pad and picked up somebody's DNA from that store. And now you have DNA on your hand and on your coffee cup of a person that you've never even been in the same room of. Isn't that crazy? Ain't that crazy? It is not possible to establish from the amount of DNA recovered from a surface whether the DNA was deposited there by a single touch or by regular use. It is not possible to use the amount of DNA recovered from an item of interest to inform whether the DNA was deposited by direct contact or indirect transfer. It is impossible to know from the quality of a DNA profile obtained whether the DNA was deposited by direct contact or indirect transfer. Well, maybe not the quality, but the quantity in which you picked up stuff. And it doesn't seem like there was enough for what they're trying to claim. Let's see. They're talking about something written by G. Meakin and A. Jameson. The authors introduced the concept of trace DNA, defined DNA that cannot yet be attributed to an identifiable body fluid. The authors rejected the term touch DNA as misleading, as such a term infers that the DNA recovered from a surface got there via the surface being touched, and that is usually not known. That's what I said, because touch and contact might give that false illusion that the only way that it can actually get there is by actual physical touch and contact. So yes, that actually makes a lot of sense. This review was followed by a similar review article by a different group of scientists 6 years later, which reached similar conclusions. Appropriately trained forensic practitioners are best placed to provide opinion and guidance on the interpretation of profiles at the activity level. However, those requested to provide expert opinion on DNA-related activity level issues are often insufficiently trained to do so. We advocate recognition of DNA activity-associated expertise to be distinct from expertise associated with the identification of individuals. This is to be supported by dedicated training, competency testing, authorization, and regular fit for purpose proficiency testing. And, the Orshot test. Yeah, that's the orange juice one, I believe. DNA transfer in forensic science, a review. All they really have to do is pull up that one YouTube video. That's really all anybody needs to watch, is that one YouTube video that has all the little diagrams. It's literally perfect. The term activity level refers to the question of when and how of what happened. Such, how did the DNA come to be on an object, and how long had it been there? Footnote number 6. And it's just an article from Forensic Science International 2018. That's all that was. Oh, where was I? I don't even see the little bitty 6 anymore. Okay, right there. Okay. Examples of indirect transfer of what might be characterized as touch or contact DNA are numerous and are summarized in the 2 review articles described above. Van Orshot et al. Discussed the use of the term touch DNA as one that can be misleading, as it implies a specific mode of action and to some degree also a type of biological source. Using a less descriptive term, such as trace DNA, is a more appropriate term to be used in casework when the source and mode of deposition are unknown. I mean, I agree. I definitely do agree. I get the point. The article is an illustration of how extremely complex the question of how and when is given the identification of a sample that has no biological source, such as blood. And then number 7, the author cites 298 published articles in the area of DNA transfer. That's a lot of articles that they put together for that. Okay. Van Oorschot et al. Summarized the routes of transfer considered in the body of research in the illustration below. I mean, I wish they would have used the other one that we went through because this is a little bit blurry. And I feel like the other one was definitely a hell of a lot better. Okay. So this is an example of primary transfer where you're actually like it's on there. And then this shows that this would be indirect transfer, but it's not really showing like how the transfer happened. See, I don't like this. That arrow doesn't really tell me much of anything. Indirect deposition, multi-step transfer shown here as primary through quaternary. Simultaneous, direct, and indirect. See, this person touched this thing and then transferred it onto this other thing. That's the main example that I always use. Bidirectional transfer, meaning it could go either way. Multiple contacts. It's put here and then transferred here, and then somehow or another it goes multiple places. Interrupted pathway. Yeah, see, like I kind of get like what they're trying to say, but I really wish they would have done it with like real life items. DNA parking? It's a wild statement. I don't know what that means, DNA parking. Despite this wealth of information and scientific study, the authors conclude that more work is necessary and that the expertise to offer activity level opinions, the how and when, is beyond the expertise of crime lab analysts. Then in 2024, NIST, the National Institute of Standards, published a document entitled Forensic DNA Interpretation and Human Factors, Improving Practice Through a Systems Approach. And we have a website. Does it work? It works. It is 436 pages. So I will take this and put it in the chat for anybody who wants this school book to go through. This document was the result of extensive work and years of public review and comment. The Expert Working Group, EWG, on Human Factors in Forensic DNA Interpretation began work in 2020 with the goal of recommending strategies for improving the production, evaluation, and communication of DNA results. The EWG consisted of experts in the field of forensic DNA and was subject to repeated rounds of public comment from the greater forensic community. Most notably for this court, the EWG addressed the question of transfer and the ability of experts to proffer opinions. The EWG addressed the following question. But a further important question is what activities led to the presence of that DNA? With the increased sensitivity of DNA techniques and sophisticated software, a DNA profile may be developed even when the contributor of that DNA may never have touched the item or area that was swabbed. Exactly. Alternatively, a person's DNA may be present when they were not involved in the crime. Exactly. Therefore, considering how or when the DNA may have been deposited or why it was not recovered can be vital. Except in ground truth known experiments where an individual is observed to have been in contact with a surface/location, it is not possible to know whether the transfer was direct or indirect. The assessment of what is called TPPR, transfer, persistence, prevalence, and recovery, is a separate skill distinct from standard DNA profiling and interpretation. There are not adequate educational opportunities to inform these types of issues within the United States. The EWG concluded that an expert rarely, if ever, has all the information needed to perform a robust, balanced, and transparent evaluation of biological results regarding transfer or specific activities on the witness stand. The EWG offered proposed responses to questions of how and when DNA arrived on an object, none of which include a statement of how. And then I guess this is a portion of that link that I just put down in there. In your opinion, is direct transfer more likely than indirect? DNA analysis does not allow a scientist to directly answer how the DNA was deposited. The DNA results presented in my report regard the comparison of DNA profiles and can only help answer questions about whose DNA may be present or not. My testimony about the value of the DNA comparison is only meaningful to help the jury determine who the source of the DNA was. The testimony does not provide any information that addresses the issue of how or when could this alleged activity have happened. Offering an opinion on this question would amount in speculating on what is alleged. It is not my role as a scientist to speculate about or determine what happened. Is it possible that the DNA was deposited when the person of interest engaged in an activity at the scene to or after the alleged event? It is not my role to discuss the possibility. So it's basically just saying that they really can't answer all of these things, literally at all, and they're going to find a way to argue with it for why they can't answer it. The only conclusion that the court can draw is that opinions regarding the means and manner in which DNA was deposited on an item is not considered a proper topic of expert opinion for a DNA analyst and likely to lead to undue prejudice to Mr. Kohberger and would render his trial fundamentally unfair. This court must exclude the opinion of Rilene Nowlin. As set forth above, an expert cannot offer opinions within their expertise. The expertise of the typical lab analyst is not sufficient to allow them to be considered an expert in the area, the mechanism of DNA transfer. In the area of the mechanism of DNA transfer? I feel like they're missing some like little bitty words. Either that or I'm like really tired. Nowlin's disclosure concedes as much in that she acknowledges that current methods cannot conclusively offer an answer to the question of when and how. Nowlin cannot be allowed to substitute her judgment in the face of the weight of the forensic community's agreement that the science and literature does not support any analyst testifying about when and how of transfer. This opinion falls outside the norm for forensic DNA experts and would be highly speculative. Given the nature of the opinion proffered and the recommendations in the NIST Human Factors Report, this opinion would be highly speculative. In addition, it would have the tendency to mislead and confuse the jury and would require undue consumption of time to refute with the scientific articles and reports that clearly conflict with this proffered testimony. C. This is disclosure. This is disclosure is not proper rebuttal testimony. Do y'all see this? Like, I know that I'm tired. I can feel myself getting like extremely tired in the way that I'm speaking, reading, and the way that my eyes feel. But I know that I am not delusional. At least not whenever I'm reading. Like, I know damn well this is not supposed to say it like this. They really are just like missing a bunch of words, right? This is disclosure is not proper. I know that I'm not tripping. I know that they're just kind of dumb. Nowlin's disclosure contains an opinion that is not rebuttal, but appears to be the state's theory of the case, that the DNA for Mr. Kohberger arrived on the knife sheath via direct contact. A close reading of the disclosure for Mr. Kohberger's DNA witness, Dr. Ruth Ballard, does not contain any opinion regarding the how and when the DNA arrived on the sheath. This testimony should be excluded. This court must exclude the use of the terms touch or contact DNA, and then we have a 9th footnote. This prohibition should apply to both the questioner and witness and the use of this term in opening statements. While this motion is focused on Ms. Nowlin, the generic statements in the disclosure for DNA witnesses raises the same concerns, and this motion should be applied to all witnesses. It should say witnesses, but it says a witness to all witnesses who testify about DNA. Okay. There's the number 9. Okay. Under IRE 403, this court may exclude the use of the terms touch or contact DNA if its probative value is substantially outweighed by a danger of one or more of the following: unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. This rule requires the court to balance the probative value of the evidence against the danger that the evidence may be unfairly prejudicial. Here, the terms touch and contact are misleading, and that the forensic community has determined through empirical research that it is not possible for a DNA expert to testify as to how DNA was deposited on an item. The two terms insinuate that the deposit must have come from direct contact with an object rather than the myriad other possible means of transfer documented in the literature. Furthermore, allowing testimony regarding the manner in which the DNA was deposited on the sheath would implicate the same concerns that the use of the two terms touch and contact invoke. The forensic community consensus and an extensive body of research shows that the how and when opinions in DNA testing far exceed the expertise of a DNA analyst and are not founded in science. In this case, the only DNA evidence that implicates Mr. Kohberger is the DNA found on the sheath found in the residence. See, the defense has never once ever came out and tried to say that it wasn't his. Literally ever. From the lab reports and notes, as well as recent testimony by Riley Nowlin, it appears that at the sample Q1.1 was a swabbing of the leather strap on the sheath as well as the interior of the snap, not the outer snap surface, which apparently was not sampled in order to preserve the surface for fingerprinting. No serological testing was done on the area swabbed for Q1.1 to identify any biological material. And we go to number 10. Other portions of the sheath were tested for the presence of blood. Okay, well, we kind of figured that. An area identified as Q1.4, swabs of stains on back of the sheath, tested presumptively positive for blood and was DNA tested. Mr. Kohberger was excluded from this particular sample, which was identified as a mixture. So the blood was multiple blood. Honestly, it's probably Maddie's and Kaylee's if it was on the bed. It would have to be the mixture of Maddie's and Katie's, but hopefully they tested them all the way down. I doubt it. Thus, the government has the burden to prove the when and how of the DNA identified in Q1.1. Allowing the use of these two terms would mislead the jury to believe that there was evidence to support the conclusion of direct contact, when in fact there is no direct evidence. None. The admission of these terms would lead to a substantial waste of time, in that it would require not only extensive cross-examination of the government's witnesses on the topic, but also rebuttal testimony from defense experts on this question. Furthermore, the use of this language would unfairly prejudice Mr. Kohberger. Unfair prejudice is prejudice that tends to suggest a decision on an improper basis. If the language is used, the jury might well believe through expert testimony, as opposed to factual testimony, that Mr. Kohberger left his DNA on the sheath via direct contact, a fact that the government must prove. As the consequence, there is a danger that the jury would reach a decision on an improper basis due to evidence that is unfairly prejudicial. Conclusion. As set forth above, the forensic community has come to a consensus that DNA analysts do not have the expertise to render opinions on how and when a DNA sample arrived on an object. In addition to being misleading and inaccurate, allowing such testimony would result in an undue consumption of time. This type of opinion testimony would not satisfy IRE 703, and that the expert cannot be qualified to proffer such an opinion because it falls outside the expert's specialized knowledge. The question of how and when is not for a lab analyst, and as the EWG points out, there is no training program in the United States that would provide expertise for such an opinion. Mr. Kohberger respectfully requests this court grant his motion in limine to exclude any use of the language touch and contact in the context of the DNA testing of the sheath, and any opinion of how and when the DNA on the sheath was deposited. And we have another one by Becca Barlow. Ashley's Activism. Thank you so much for the $4.99. I appreciate it. Thank you very mucho. The docs are gone. I'm reading them. What you mean? So are you telling me that I'm going to refresh this page and they're going to disappear? They're still there. The docs are here. I just refreshed the page. Like every time you see it pop, bump a little bit, that's me refreshing the page. They're still here. Now I know that I went to like the home page earlier, and this page was acting crazy, but I could still get the documents to pop up. Yeah, like it was acting crazy all day because they've been doing no site key. Yeah, probably because it's been updated. Yeah, because it seems to be okay. Let's see what this one is. This one's only 3 pages. We can do this one. I'll stay on for like another 20 minutes. I'll get off at 11:30. So we should be able to go through this one. This is an interesting one because the I think this is about the traffic stop. I think it's about the traffic stop. I might be wrong. Yeah. This is about the 404B form where we were told by the state that they were admitting the traffic stop from, I believe, Corporal Duke, the Duke guy, from August 21st in Moscow. And it was like 6 miles, I think, from King Road, something like that. They already told us that the reason why they submitted the traffic stop was for identification, phone number, address, and vehicle identification. Okay. In the rules, and we read the rules whenever we went over this in the video that I put out, whenever this video came out, in the rules, it says that this can be used for proving motivation, planning, premeditation, all the things, okay? But it has to be mentioned. It has to be said. It has to say that. They had to have said that they are putting this in evidence to show that he was planning the event. And that's not what they filed it for. They did not bring it in as evidence for anything other than identification, phone, address, and car. Now they're talking about how apparently there's something to do with that document, the 404 evidence relating to that situation. So let's see what it says. Motion in limine number 8, unnoticed 404B evidence. Comes now Bryan C. Kohberger, by and through his attorneys of record and pursuant to the Idaho Rules of Evidence, moves this honorable court for an order in limine excluding any 404B evidence. As of the date of this filing, the state has only noticed a prior traffic stop as 404B evidence. Mr. Kohberger moves that any other 404B evidence be precluded from presentation at trial. Because deadlines for filing motions in limine are not staggered, Mr. Kohberger is forced to guess what the state may seek to introduce. Rather than guess, he seeks to exclude all unnoticed 404B evidence. Upon the state's timely filing of 404B evidence, Mr. Kohberger will object as appropriate. Additional support for this motion includes the United States Constitution amendments, those damn Roman numerals, the Idaho Constitution, Article 1, Section 8 and 13. Argument. Idaho Rule of Evidence 404B states, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion, the person acted in accordance with character. He got a seatbelt ticket. He got a seatbelt ticket. Permitted uses of other crimes, wrongs, or acts is when the evidence is being used for another purpose, such as proving motive, opportunity, intent, preparation, plan, knowledge, identity, absence of mistake, or lack of accident. And they literally are only using the damn thing for identity. We went through it. IRE 404B2. The prejudicial, wow, I really said it that way. The prejudicial, I can't talk all of a sudden. I have got to go to bed here soon. The prejudicial effect of a crime, wrong, or act, yeah, I do. He's in there. He needs to go to bed. Is that it induces the jury to believe the accused is more likely to have committed the crime on trial because he is a man of criminal character. Character evidence, therefore, takes the jury away from their primary consideration of the guilt or innocence of the particular crime on trial. The drafters of IRE 404B were careful to guard against the admission of evidence that would unduly prejudice the defendant while still allowing the prosecution to present probative evidence. For the reasons addressed above, Mr. Kohberger respectfully requests this court grant his motion in limine to exclude any reference to 404B evidence that is unnoticed. And I'm going to assume that means that he doesn't want them to file anything else. Because they can't say that the traffic stop is unnoticed because it's filed. So, again, it's only in there for identification purposes. I don't really see, I mean, but then again, I understand why they're trying to, like, I guess really sort of take a lot of special care with the psyche of the jury and the way that they're going to be presented information. You know what I mean? Okay, so we went through all of these down to, what was it, number 8? Now, I'm going to end this by showing you 2 documents that were filed from the state. So far, we've gone through everything for the defense, but I wanted to go ahead and show you guys these on the live because I thought, just me assuming based off titles and things that we have seen happening with the Goncalves family in this case, be it their shirts and their voices, okay, I really thought that the motion in limine for immediate family members and something about improper death penalty comments, I really wholeheartedly, with all of my little brain and heart, thought that the Goncalveses were going to be kicked out of the courtroom because they've made insane comments about the death penalty, wore the shirts. Steve Goncalves literally went on an interview, I think after the 23rd and 24 motions, and mentioned something about how they're not there to just talk about the firing squad. He is the firing squad or some crazy alpha crap like that. I don't know. I haven't even been paying attention to them, honestly. But I was wrong. It has nothing to freaking do with that, literally at all. And I wanted to show you guys these 2 documents. So, again, this is from the state. I'm pretty positive. Yeah, this is for the state. We're going to go through these. These are going to be the last 2. State's motion in limine regarding the immediate family members in the courtroom. Let me go up one more. Comes now the state of Idaho by and through the Latell County prosecuting attorney and respectfully moves the court in limine for the following: guidance from the court regarding who the court recognizes as immediate families under IC 19-53063 and State versus Payne from 2008. Not the same Payne. Hopefully it's not the same Payne. And number 2, an order allowing those immediate family members to remain in the courtroom for the entirety of the trial currently scheduled to begin on August 11th of 2025. So who would be not considered immediate family? Who would not be considered immediate family? I guess like cousins, aunts, uncles, stuff like that, but like your parents and your brothers and sisters are definitely immediate family. What would they consider grandparents immediate family? Because I know that the Goncalveses have made a big deal about how they need to spend thousands of dollars a day because of all these freaking family members and all these pets and all these crazy crap that they're trying to do. But they probably shouldn't be thinking that way. They should be thinking all of Kaylee's actual siblings and just them 2. That should be the only people that should be in those Airbnbs and staying in Boise. But there's also going to be like a lot of people because you have to think about it. Xana had 2 families because her parents were split. Ethan's parents were still together. Kaylee's parents were still together, but Maddie's parents were split. So that's multiple parents, multiple sets of parents. The state is requesting an order pursuant to Idaho Constitution Article 1 and Idaho Code 19-53061B and 3, allowing immediate family members of the homicide victims to be present during the entire trial, regardless of when they are scheduled to testify. I mean, that's normal, though. I feel like that's normal, that they've always kind of just been allowed to sit in the benches, right? Yeah, it's actually smaller. Like, they tried to act as if Boise was going to be bigger. And Boise's not bigger. Like, the courthouse itself, the system, the jail, those things might be bigger, but that freaking courtroom, there's, like, no benches. There's, like, no room. There's really, like, no room. Okay. The Idaho Constitution, Article 1224 states, a crime victim, as defined by statute, has the following rights: to be present at all criminal justice proceedings. Each victim of a criminal or juvenile offense shall be permitted to be present at all criminal justice proceedings. The statute extends this right equally to the immediate families of homicide victims. The legislature did not define immediate families in this section. Nonetheless, the legislature has defined it elsewhere. For instance, in IC 41-13252, immediate family member means a parent, mother-in-law, father-in-law, husband, wife, sister, brother, brother-in-law, sister-in-law, son-in-law, daughter-in-law, or son or daughter. So it has to be just one generation away from the victim. That's the only thing that, or a brother or sister, because that's the same generation. So same generation or only one generation off, forward or backwards. Likewise, in IC 441601, immediate family member means the spouse, children, brother, sister, mother, or father. That's pretty much like the same thing. Black's Law Dictionary defines immediate family member as one, a person's parents, spouse, children, and siblings. So that means that, like, none of, well, I can't say none because Ethan and Xana were together, but Maddie's boyfriend at the time and Jack D can't be there? Is that what they're going to say? That Jack D can't be there? That's wild. I wonder if they're going to have Murphy come in and see if he reacts. I think they probably should have done that already. And that's the Black's Law Dictionary from 2004's 8th edition. And then it says the state has attached a list of the immediate family members the state believes should be considered victims by statute and therefore should be allowed to be present if they choose during the entire trial, regardless of whether or when they testify. See State's Exhibit S1, and it is attached. What would they testify about? Besides, like, the part where they get to testify and, like, read their impact letters if he gets convicted and stuff like that. But I don't know what they'd be testifying about, like, during. Unless they just get up there because they're supposed to talk about the victims, I guess. I'm not really quite sure how that all works. I don't know. I'm not really quite sure. The state respectfully moves for an order of limine specifying immediate families under IC 19-53063. I read that part. Okay, so where's the list? See, we don't get to see it. It says it was attached, but every single exhibit for the motions in limine are being filed under seal. So it's not here. But we know the family. We know the families. But that also means that, like, all of Goncalves' little tag-alongs that he likes to have up his butt following him like a little lost puppy dog, they're not going to be allowed to just be popping up in that courtroom either. So there's that. I don't know why they couldn't just give us the list. Because, like, the judge mentioned something about using initials and using relation to the victim whenever you're talking about the person, instead of just, like, full on using the name. I felt like that would have been an appropriate situation to use that. Okay, so now we're going to open up the one about the inappropriate death penalty comments, because again, I was wrong about who this was about. I really thought that it was because of the Goncalves' craziness, but it's not. It's not at all. It's actually because the state doesn't want the defense constantly saying that they're just trying to kill Bryan. That's literally what this is all about. Comes now the state of Idaho by and through the Latah County prosecuting attorney and respectfully moves the court for an order in limine prohibiting the defense from making any reference to the state attempting to kill their client, Bryan C. Kohberger. The state brings this motion based on defense counsel's repeated references to the state attempting to off their client. On October 26th of 2023, defendant in his reply to state's objection to defendant's second motion to dismiss indictment on page 18, he states, the state has decided to attempt to off Mr. Kohberger. On October 26th of 2023, during oral argument on the defendant's motion to dismiss the indictment, defense counsel stated, this does not rise to what we would expect our government to do in this scenario where they are trying to off one of us. Again, on January 25th, 2024, during oral arguments on the defendant's motion to reconsider, defense counsel stated, particularly in a case where the state decided that it wants to try and off someone. And there's apparently audio of that, but that's from the 25th. Oh, that's from 2024. I was about to say we did not have a January 25th hearing. I would have known about that, but yeah, no, that's from the 24th. Okay, that makes more sense. Pursuant to 18404A, the state has filed a notice of intent to seek the death penalty. Upon a finding of guilt, the state intends to provide statutory aggravating factors which could enable a jury to impose the death penalty. This is the process laid out by Idaho law. Any other characterization, such as the statements that the state is attempting to off, only serves to inflame the passions of the jury. The statements are irrelevant, i.e., does not make a fact more or less probable, has no consequence in determining the action to the issues before the jury, the guilt or innocence of the defendant of the charged offenses. IRE 401. In addition, such statements carry the substantial danger of confusing the issues and misleading the jury, thus failing the IRE balancing test, even if deemed relevant. IRE 403. This is further supported by the Idaho Criminal Jury Instructions, which instructs the jury. At the conclusion of trial, you will decide whether the state has proved the defendant guilty beyond a reasonable doubt. Do not concern yourself with the subject of penalty or punishment. That subject must not in any way affect your verdict. Well, then why don't they trifurcate it instead of bifurcate it? If they really want that to be the case, why don't they trifurcate it instead of bifurcate it? That's been the entire argument, which is why we're having all of these death penalty filings happening right now. And like I've mentioned, 3.5, 4 hours ago now, Nancy Disgrace is out here lying to her audience, telling people that it's them trying to claim that Bryan has now admitted to doing something, and now they're trying to say that his autism made him do it. That is not the situation at all. But because of it being bifurcated, it having to be in 2 parts instead of 3, all that information gets filed when it doesn't need to be filed and causes a bunch of confusion, just like Jennings here is actually like talking about. For the above reasons, the state requests the court prohibit defense counsel from making any reference to the state attempting to take Bryan's life. Oh, what is this? Audio file on thumb drive, hand delivered separately. So it's just about what was said in court. Yeah. That's wild. Definitely not what I thought it was. It was not what I thought it was. Literally at all. It really did make it seem, at least in my brain, because of everything that we've been listening to, that the Goncalveses were up to some cray-cray and they were being kicked out the courtroom. That's what I really thought it was. So yeah. That's wild information. I think the most like prevalent part is the fact that in Dylan Mortensen's brain, the eyeballs on her wall are who did it. Yeah, apparently Nancy Disgrace is not allowed to be an attorney ever again. I will probably do a deep dive into that one day. Because I don't like her. I'm just wild. I have somebody with some personal stories about her nasty self too. Some nasty stories. Yeah, I think Miss Nancy, especially since she knows who I is, okay? She got me blocked on Twitter. She has me hidden on her freaking YouTube channel. But Joe Scott Morgan follows me. So she knows who I am. Let me say something. Let me do a deep dive down Nancy Lane and find out exactly why she does not deserve to be out here. I'm telling you right now, there's something wrong with her. This video, I'm going to go ahead and I'm going to drop it in the morning. I'll probably drop it like at 7:30 just so that it can just be out there and it'll be out before I even wake up and it'll be fine. But every time I watch one of her Idaho videos, she looks more unhinged. Her eyes are glossy and like red the entire time. And I don't mean like she's hitting a vape or something off camera. There's something going on. And she yells and she's so mean. Like, I might go off on somebody that's being a complete dill hole in the chat every now and then, but for the majority, I don't need mods and I do not need to babysit. You guys got this. Y'all all have brains, okay? But when it comes to her, like, how can you be so freaking mean to people? Like, she's sitting there trying to like get people that are like been on her side for years to agree with her in this last Idaho video. And even Joe Scott's like, no, you're wrong. No, you're wrong. McDonough's not really agreeing with her either, which is a huge freaking first. She's cutting people off left and right. She's wild. She has lost her ever-loving freaking mind. Just be ready, though, because it's me watching the entire video. And it's long, because I literally got shit to say, like, every freaking 10 seconds. Like, she starts with a lie. Like, her first fragment of a sentence introducing her freaking show is a lie. And I'm cracking up the whole time as Joe Scott's going off on her. I'm like, yes, finally. She's all kinds of flustered. I love it. Yeah, I'm going to drop that one in the morning. I'm going to drop it in the morning. Her kids are even surprised that she's that mean on TV. There's no way that her eyes are that glassed over and red just for TV. Like, either there's a medical condition happening or she's on something that makes her that way. It's just insane. Just insane. So we will go through the rest of these probably tomorrow. We went through crap tons of them. I definitely doubled the time I was on here. I said 2 hours, but we went 4. But that's because I got a bunch of stuff handled ahead of time and it was fine. And we went through more than just like... Somebody just said something. Yes. She loves her some whiskey, from what I'm hearing. I just hear things. I've heard things. I've heard personal stories that made me want to gag. But those probably won't be brought out. Because they're not my stories to tell. I just had the misfortune of hearing them. She's something else for sure. Okay, I'm going to go ahead and get off of here. Probably go watch Grey's Anatomy or something. Y'all, I feel kind of dumb sometimes because I want to go on my second channel and post about like my rant that I have about the damn Grey's Anatomy show, but I've done it like once or twice and everyone's like, have you never seen that? It's forever old. No, I'm currently watching it. Me and Ariel started it and I'm trying to finish it. And yeah, that show drives me crazy. I want to talk shit about it on my other channel, but then I'm like, no, because people think I'm dumb. So we're just not. But yeah, I'm gonna go ahead and go. I will set up the live for tomorrow at some point, probably starting at like 6:30, just so that we can start a little bit earlier to go through stuff. I'm on 8, I think. I'm on 8. I don't know if I should like say what just happened. It's for you to know what just happened because there might be some people. Yeah, you did. You did. There might be some people that don't know it. Let's see. I'll say we just got past the airplane stuff. If that makes, yeah, you know what I'm talking about. Yeah. Yeah, I'm gonna go ahead and go. I will see you guys tomorrow. Thank you for the gifted memberships. Thank you for the people that became a member on their own. Thank you for the people that gave me some super stickers and the super chats. And just thank you all for sitting here for 4 hours listening to me rant and ramble about these docs and complain and say words wrong and all the things. You guys are awesome. You'll have a great night. Get some sleep. We will do this again tomorrow. Let me go. Do I have my thingy on here? Oh, I didn't even do my what you call it thingy. Let me do this real quick because I talked some shit in this one.
Everything stated in this video is my opinion and my opinion only. And just like everything else in these cases we discuss here on this channel, everything is alleged.
Figured I probably needed that one. All right, I'm going to go ahead and throw the outro up here. You guys have a super great night. See y'all.